on this?
Only on that I'll clarify.
Please clarify and
And
please
in the meantime, I'll also,
ascertain.
though it is not part of the record, I'll ascertain whether it is realized from past brothers or not.
Yes, that is why we. And please come with the then exact figure, how much you will pay. In fact, we have recorded
In
your.
that case, I'll pay 139, the entire amount that the bills we have already verified.
Then if that 139 pay order can be brought, we need not dwell into your arguments, their arguments and everything. We will dispose of on that basis.
I'll try to impress upon my client accordingly. But by tomorrow, Malad, I doubt I'll be, even if Malad, I'm in a position to bring a pay order, Malad, I doubt Malad I'll be able to do it by tomorrow.
All right, let it be tomorrow.
We will get tomorrow, Malad.
We will recall our unsigned order because that at the time of signing we noted this. So please, if you can inform Mr. Roy
I'll
also,
inform Mr. Roy.
but mamlata to be mentioned above. If you cannot get that instruction, what we were desired us was to bury the hatchet, the amount which you are admitting to pay, whether you can pay that amount or not. Then we need not set aside his lordship's order.
Yeah.
Yes.
Malad, may I have your lordship leave to mention a very urgent matter, Malad? Malad, it's a tender matter where the tender is under challenge. The last day of submission of bid is 9th of May. Malad, I only have Malad tomorrow to pursue my matter before your lordship, Malad.
Who is your other side?
Malad, there are 3 oil companies. Mr. Kaur argued the matter. Mr. Kaur, Learned Senior Counsel, argued the matter on behalf of BPCL. Mr. Bishwanath Chatterjee is there for one of the oil companies, and Mr. Amit Nag is there for another oil company.
So when was the order
Mr.
passed?
Nag is there for the Union of India. So, Malad, Union of India is just.
Now, when was the order passed?
The order has been passed yesterday, that is 6th of May.
Leave the
Well, leave to file
notice to all.
And Malad, also Malad, may it be listed tomorrow, Malad.
List for the leave the.
State alag.
But you have to bring all the others.
I'll give notice, Malad. I'll talk to them.
Yes, call the list.
Paying for the appellant in this matter, my lord, I'm led by Mr. Shobhashadi Chaudhary.
Oh, that way.
On the last occasion, my lord, it was submitted.
Oh.
Because we are getting supply from a different person now.
Yes, yes.
So there's no question of payment and no question of withdrawing, giving supply.
We will dispose it of, recording your statement that you have obtained supply from somebody else.
There's only one thing, my lord, like in they say that businessmen, my lord, they cannot afford to fight with government organizations. DVC and West Bengal State Electricity Development Corporate Distribution Company are both state organizations. Tomorrow, lo and behold, if DVC, the situation arises when I have to approach DVC for supply. They will say, point is not decided. You pay.
That is why you make up your mind. That is what we
kindly hear out the appeal on that point.
Point on which point?
That whether or not any liquidation sale.
That's beyond the scope of this appeal.
No.
Yes, you see, you are limited to your claim vis-a-vis the fact that you purchased this from the erstwhile Badrinath. So it's Badrinath's dues. For Badrinath's dues that DVC said we can't supply you unless you pay. Now, what you're now saying that at a subsequent stage, if I do apply and they cite this reason, hence you decide the appeal, we think that it's a bit beyond the scope of this appeal.
We will take note of that. We will say that we defer our endeavor to consider that issue in an appropriate case in future. Finish.
Your lordship can say whatever. I'm not for a moment suggesting what your lordship should say. I'm just making my humble prayer.
No, right, but we wanted to ascertain as to whether you are taking connection because the junior was there. We didn't want.
It suddenly appeared, my lord. We have taken connection from West Bengal from alternative supplier. We are running the factory. Your lordship wanted to know whether we were resolution applicants because I have shown a clip. We have never been a resolution applicant. We only participate in the liquidation. Resolution process failed.
Show us the order which you impugned in the writ petition, the demand of theirs of.
Yes. Writ petition, my lord. The order starts at page 20.
Well, 133 is the demand made by the licensee, my lord.
Page 1.
33 of the application, my lord. And my lord, the order impugned is at page 20 to 48.
One 133.
Page 133, my lord, of the writ petition.
Of the application, my lord. Stay application, yes.
Stay
July.
application.
19 July.
Yes, my lord.
Stay application. Thirty-three of the stay application.
An order. That's the page 20.
Dated order.
Order impugned of-
This is 19/7/21. They say we will give you supply only if you clear Badinaran. Well, my point was very simple. For the trial judge, your lordship sees the judgment that in a liquidation sale, Hydra heads cannot pop up because no one will come forward. I have bought on a slump sale basis, as is where is whatever there is basis. I have not bought the company. As a successful resolution applicant will not takes over the company and the liquidation is resolved in that sense. Everyone is satisfied apart from the unsecured creditors perhaps.
Page 47 is, my lord, the order.
Now, my lord, what has happened here? What has happened in this case is I bought on a liquidation sale. I paid the price.
Has DVC not applied as a creditor?
Yes.
It has filed its claim before the liquidator. Now, whatever it
The
gets,
same amount.
yes, whatever amount I don't know, it has filed its claim before the liquidator. Section 53 of the code, your lordship knows the waterfall mechanism. I don't have to go through it again. So they have to pursue the liquidator.
My lord,
Prabhu
my lord, regarding if my lord is hearing this matter, my lord, Mr. Shobhasati,
Just for our
your lordship is not hearing your lordship.
my lord, regulation, there's a specific regulation 4.6.4 which does not bar the licensee from recovering the dues also, in spite of the fact there's a mechanism.
be a nexus.
My lord, there is a nexus. My lord, that nexus point has been cleared. My lord,
Is only if you can establish a nexus.
yes, my lord,
between the-
that nexus point has been cleared in the division bench judgment of this Honorable High Court, my lord, which on the last occasion Mr. Chaudhary was relying on day before yesterday, my lord has.
The appeal is from the judgment of the single judge.
If my lord
See
keeps
what
it in the
argument was. They have not, they did, single judge said, if there is a nexus, you show me.
My-
They did not plead nexus, nothing in
My lord has
opposition.
kept this matter
nothing.
or specifically on the prayer of the respondent, my lord, that whether they
If he
they
doesn't
are-
want to argue the matter, I am not saying anything. If he doesn't want to, if he's unprepared, doesn't want to argue, so that's the one thing.
my lord, today is kept for to be mentioned, my lord, because specifically on.
He was about to
Let him start.
you were not there yesterday.
No, I was not there because I was not.
Not say that they were not ready yesterday.
No, today here. He is not here today.
It appeared yesterday he was ready, and today we kept it only to ascertain this fact.
No, your lordship will kindly decide, because suppose.
Today was kept, Mr. Mitra, you were not there.
No, I was not there, yes.
Had asked your learned junior to produce, if at all, some sort of a resolution to say that.
It has to be signed by a director.
I'm aware of that a board resolution.
Your lordship will hear out the appeal. My prayer is up.
You have it, madam. You were there on the last day. Do you have the resolution?
No, we don't have it now. But my lord, I kindly hear out the appeal. They have preferred an appeal. Is their appeal? Kindly hear it out. Whether or not in a liquidation sale.
So, Mr. Mitra, what we are wanting to know,
Yes, my lord.
the contentious issue in the writ petition was for providing such supply, this amount is required to be paid or not.
They say, yes.
That was the contentious
Yes. Correct.
court held in your favor.
Need not be paid. Need not.
be paid. All right. Now against that they have come.
Yes.
We will record your submission that at the present juncture you have availed services from a different entity. And as this issue which we are not deciding, we will keep it open to be decided in any subsequent litigation. We will record that.
My lord, my single bench judgment, I have succeeded. Now, unless that is overturned by your lordship.
You are not interested to take it from DVC now. Is it possible?
Tomorrow I may apply to DVC for a supply. Switch on.
This is another submission here. On apprehension, you are saying that you record this. And we are recording. We will say that this issue we are not deciding. It will be left open for an appropriate case in future.
And the
What is-
appropriate case, when it happens, will suppose, in the event, will not I want supply from DVC. Will kindly keep it after the vacation, will kindly keep the. Your Lordship can give directions to informal paper books, because paper books were dispensed, not informal.
Yes, we'll consider on the next.
My lord, all records are there, my lord, before my lord.
Call the next matter.
Yes, call the next matter. Over.
But 5, I appear on behalf of the private respondents.
Case of the petitioner.
এক সেকেন্ড ধরো একটা জিনিস বলে নিন, একটা জিনিস বলে নি তারপরে তুই পড়।
First matter. চোখে মুখে সেই জন্য চেয়েছে
I appear for the private respondent in this
For the
matter.
status.
My lord, before my learned friend starts for the appellant, my lord, I would like to inform this honorable court that, my lord, this entire issue devolves into a round from a, my lord, Ismaili unpartitioned property, which was a part of it was sold to my learned friend's client, and part of which has already been sold to a third party by the private respondent herein. My lord, hence, my lord, if the private respondents who are supposed to be made party in this present writ petition are not parties as yet. My lord, my learned friend appearing for the appellant is appearing for a party.
Were you the plaintiffs in the suit?
My lord, I were the plaintiffs initially.
Then what happened?
My lord, thereafter there was an allegation from our side as well as from their side. Now the persons who are presently
No, we are in the partition suit which
Yes.
was there.
That was
Were you the-
dismissed.
Huh?
That was dismissed.
হ্যাঁ বলছি ওটাই
Were you parties to?
Yes, we were parties, and they were also not parties. The respondent number 9 and 10 are the predecessor interest of the present owners.
Yes.
Now, what has happened is the present.
Place my case.
না না ওটা না হলে মুশকিল হয়ে যাবে। Now, I appear for those.
They are not parties here.
The present owners are not parties against which my learned friends are having a loggerhead in a separate partition suit.
That is no longer there.
No, there is a partition suit, my lord. I have got information.
No, it has been dismissed.
No, that is dismissed. The previous partition suit was dismissed for default.
Then what? Any other partition?
Now there is a partition suit between the present owners and my learned friends.
But we are not.
My lord, there is a summons issued.
And we
that
have
is
not heard about it.
Achha, tell us what is your problem?
Well, my case is that, my lord, the Robindra Chandra Mondal is an absolute owner of the property. My lord, he has only one son, Dinesh Chandra Mondal, and Dinesh Chandra, from the Dinesh Chandra Mondal, we got the 9 decimals of land out of 41 decimals of land.
Dinesh was a son
Son of the Robindranath Mondal,
Ja. Robindra was the owner.
absolute owner of the entire property.
Entire property of how many decimals?
41 decimal of land.
Acha, 41 decimals. He had only one son.
One son and one daughter. Purnima
Namely?
Mondol.
Namely,
Purnima Mondol.
and
And Dinesh Chandra Mondol is a Dinesh Mondol, sorry.
Dinesh and Purnima.
Purnima. Dinesh, by way of deed of gift, my lord, entire property is given to the Dinesh by his father.
His share was given.
Entire share of the property is given to the Dinesh by the Rabindranath.
Oh, daughter was not given anything. So the entire property came to Dinesh.
Dinesh.
Now
My
Dinesh,
lord, from the Dinesh, my lord, the appellant before your lordship has purchased the property of the by a registered deed of gift from 9 decimal of land.
very good.
And after the purchase of the land, my lord, we are applied for the panchayat to issuance of the plan in our favor. My lord, plan was sanctioned. My lord, LR record of right recorded in my name. My portion of land is recorded in my name. My lord, with all this document, we applied before the Pradhan. We deposited the requisite form. We fill up the form and deposited the money to the panchayat. My lord, plan was sanctioned. After the plan was sanctioned, when we implement the plan by constructing a dwelling house in my property, the private respondent number 9 and 10 came to my property and intimated first Regis to build up the property, the house. Then they intimated that a suit was pending, a partition suit was pending. Partition suit of 31 of 2000.
Who
21.
they came means who came?
Respondent number 9 and 10. Well,
They are the
adjoining
Co-sharer,
co-sharer.
co-share of the property.
How can it be co-shared?
Well, a
Everything was
property
given
of
No, no, no,
41
41
decimal of land. Out of that, I have purchased 9 decimal
from Dinesh,
from Dinesh.
and they have purchased.
My lord, we are the co-sharers from my lord, from this Sriprati Mondol, one of the co-sharer of Dinesh.
Dinesh had no co-sharer.
My lord, Sripati, my lord, I tell you, lord, my lord,
If you
Sripati,
are so interested, you take appropriate.
My lord, I am telling. My lord, they are intimated about the suit was pending. My lord, we made a representation to the Pradhan and the police authority. So I want to construct my house in my property, which has belongs to me. Kindly assist me, as because all the materials which has built up and all the rods and irons that are taken up by the hooligan of the respondent number 9 and 10. My lord, we approached before
So
the.
9 and 10 purchased from whom?
My lord, we are only concerned about the Dinesh and we are purchased it from the Dinesh. Record of right is
What happened to the remaining portion of what?
my lord, I am telling. My lord, they intimated there is a partition suit was pending. My lord, we approached before the honorable court. Honorable Justice Mantha directed as the partition suit was pending and the suit was pending, no order can be done. You have to approach before the civil court and obtain an order. My lord, immediately we filed 141 application before the pending suit of the partition suit of the private respondent. The suit was dismissed. My lord,
my lord,
we
What are his clients?
my lord,
What are
there
we
is,
come to you.
my lord, there is a table in front of me, my lord,
What is your names?
my lord, my name is, my lord, Shadhin and Renuka. Shadhin Mondol and Renuka Mondol. We are, my lord, the
Purchasers
no,
from
my lord, we are not the purchaser. We are the co-sharer, my lord. The property, the table is in front of me, my lord. My lord, what I see, my lord,
co-sharer of which property?
my lord, of the 41 decimal of land, out of which 9 decimal was bought by my learned friend's client from our co-sharer.
So you did not go and file a partition suit.
my lord,
There was a partition.
that was
But
dismissed.
There was a partition.
Shadhin and Renuka filed a partition suit.
There was a
that
partition.
is no longer there.
There was a partition suit. It was dismissed for default.
What steps you
My
have
lord,
taken?
My lord,
we had not.
My lord, we approached before the honorable court. My lord, honorable.
We had
court
not
was
taken any steps, my lord. There were, my lord, during the
Lord,
pendency of the partition suit, there were an alienation on our part of our share of property to the present owner, that is one Masood Sheikh. As they are, my lord, also owners not from the genealogical table, we had also sold our share of property
So
to one Masood Sheikh.
Masood is also the vendor of
No.
purchaser from Dinesh.
Malad, no, my lord, I stand corrected. It's Monirul Sheikh. Monirul Sheikh. I stand
Masood
corrected.
Sheikh is
Masood Sheikh is the appellant.
appellant.
So it is in fact a battle now between
Monirul and Masood.
Masood.
Now Monirul has filed a fresh partition suit against Masood, which is there. But I have the instructions that is pending, and summons has been issued against Masood Sheikh.
Let me place my case, my lord. What is my claim before your lordship?
It is an unpartitioned property.
The appropriate court and take direction from the police authority.
But Dinesh,
It will be to approve the prayer for approval.
ওই sanction plan আছে board land record of right to
But I have given a specific undertaking before your lordship.
Partition suit, হ্যাঁ। সেটার জন্য
yes Mr.
Malad, may I have got a table. Malad, may I hand over a
Arey,
table?
you are nobody in this
No,
matter.
no. Now at this juncture, Malad,
Place it. What is it? You are
But-
not there. Yes.
My lord, kindly see first, my lord, registered deed by.
Is your plan still valid?
Yes, my lord.
Have you made Panchayat the party?
Yes.
Huh?
Pradhan is a party. My lord, I annex the document. My lord, kindly see my plan. My lord, because we start about page 75. It is a sketch map. Thereafter, my lord, page 76 is a deposit.
His lordship's order refers to a report file. Where is that report? Yes, Mr. Yusuf.
Same point, undivided plot.
Lordship, it appears from the order, Lordship, I submitted my report, and from the report it reflects that the dispute is absolutely civil and in nature, and as such the
Oh,
police
that-
authorities
that-
have
that-
no role.
Police
Have no role.
Case is not no more
Uh,
pending.
Same, it is further submitted on behalf of the state that an
Oh,
unpartitioned
suit is
property.
pending. He says someone has been issued.
Yes, Malad.
But that is separate to another. My lord, I
Same
taken
cell
Does
property.
not have another property. The same
another case, my lord. The case which has indicated by my learned friend that his suit is dismissed, and I have took a specific
Very good, but
undertook, my lord, in this petition, my lord, if the partition suit, if they succeed, my lord, we will vacate the everything. But
But
I have purchased, I have invested, my lord, everything is, my
what
plan is
you are
sanctioned.
raising a hotel.
No, my lord, my dwelling house. Everything is there. Whenever I started to construct, they come.
Lordship,
22 file the partition suit.
Malad,
My lord,
the
that
initial
is annexed.
partition.
Not initial.
No, this one I find, Malad, it's it's partition suit number 208 of 2024, which is pending. Malad, exact date of filing I have not known, Malad. Malad, it is. I have the deed by which I have transferred
So
my
what
share.
do you want from the police, Mr. Das?
My lord, I want to construct my dwelling house. I made a representation to give a police assistant. Whenever I present construction, they have come, they are a pending of partition. My learned friend, my learned friend shows that there is an order of injunction. In other court, there is no order of injunction. My lord, it cannot be. I have
There
the
were
plan.
never an order of injunction.
Malad,
There was never an order of injunction.
I telling that there is a no order of injunction. Whenever I started to construct my own house, own land, I have a sanction plan.
But unfortunately, it's a unpartitioned.
Why are you so bothered? You've sold off. You're not concerned. Poor fellow, he can't
Now, Malad,
construct
what has
his house.
happened is
My lord,
now,
they are-
Malad, the
every
present is
time they are
Let's know the
creating the
actual story.
nuisance.
no. Now the present persons who have not been made party or have come up to me to defend their
That
case.
Munirul.
That Munirul, Malad. That is the
Then the parties are the
Where's the
party
Pradhan?
was the erstwhile owner.
Who appears for the
Shadi-
Pradhan?
Pradhan also Mr. Yusuf will appear.
I'm not appearing for Pradhan, Your Lordship.
Okay, বসে আছে বোধহয়।
Having a valid license,
Then
having
I-
sanction plan, how can I exist?
Lordship,
Where is your intimation to the police?
My lord.
my role is very limited. Role of the state is very limited. I have only to maintain the peace and
You are
tranquility, Lordship.
omnipotent.
My lord, page
Those
92.
can never be
On the
limited.
3rd
Page 92.
or
Wait,
1st of
Mr. Chaudhary,
my-
we have
my-
heard you enough.
no.
You are not here. Yes.
Page 92. By intimating the order of civil court, my lord, civil court order is page 88.
Prepared for police help for construction.
Page 88 is an order of the suit, dismissing the order of suit. And
Did you apply for placing police picket?
no. My lord, my specific case, so whenever I want to raising a construction, the respondent, my lord, who was by thanks to my learned friend who was admitting he is no longer a private respondent. They came and resist me for raising construction. They, my learned friend has to.
We want to know whether your plan is still valid or not.
My lord, one thing, my lord, may I very candid before your lordship. My lord, if my learned friend is aggrieved about the unpartisan deed, my lord, property, my lord, he or the predecessor who is now in, my lord, he has to approach before the program for cancellation of my sanction plan. That this sanction plan
Changing
still
the nature
exists.
and character. Na? You are changing the nature and character. A building will come up in that.
My lord, no
Why?
order of injunction is there. My property, how the plan has been sanctioned by
Order of injunction?
no order of injunction of that partition suit, not previous partition suit, or maybe, my lord, I believe that a new suit there is no partition, no injunction is there. How can he restrain for building up a construction in my property?
Where you have said that he is restraining?
My lord, my representation is there, my lord, page 92.
Page 92.
92 is my representation before the superintendent and the officer in charge.
Has the demarcation of the land been done?
No.
Land demarcated. So how do you get your 9 decimals? How do you ascertain your 9 decimals?
My lord,
Grateful, my lord.
from the deed of, my lord,
Nothing, no grateful. Even for you, how do you ascertain?
Same here.
my lord, kindly see the deed.
No, deed will not give you a right.
Deed of 9
It's an
decimals.
unpartitioned property. Unless you've bought a part of it. So unless it's demarcated.
My lord, kindly see my plan. The
Land will
authority,
not give you a right, sir.
authority. My lord, page 75 is a sketch map of my property. At least the SP is considered my representation by giving an opportunity of that police help may be considered or not, but straightway approaching before the civil court with the case is not at all pending.
How the lordship police will decide regarding the demarcation of the property?
Land demarcated नहीं SP के representation ये change 2022 representation ये SP का change.
You earlier preferred a writ petition.
Yes.
2023.
My lord, that order is
86, lordship.
86.
86.
My lord, 86 last paragraph at the event the partition suit, page 86 last paragraph. In the event it is a partition suit, the title suit number such and such now is pending before the learned civil judge senior division, they may apply the appropriate relief. My lord, immediately after knowing that we are by filing an 151 application, my lord,
Very good, Mr. Das. But today there is a civil suit pending.
my lord, I have no knowledge about the civil.
That is what he is giving the number.
My lord, may I take the number and may come back with that?
Yes, you ascertain and say there is no such suit. Give the number just now.
Here and now, my lord, I shall. My lord, partition suit
But he
number.
will not hear you unless you take appropriate.
Hence, my lord, I had opened the case, my lord, to informing him. My lord.
We allowed you, but we will not allow unless you take
I have got your
appropriate.
lordship.
Yes, when can you come?
My lord, any day, my lord, fixed by your lordship. The suit, my lord, which is indicated by the police authority has been dismissed. My lord, if it is at all the suit is there, or my lord, I shall take it. My lord, the police should give a report.
Partition suit number 8 of 2024. Senior division. Senior division. Senior division.
You are not there, sir. How can we?
I'm get good loss.
If partition suit has been filed, then you have a demarcation will be in doubt. Yes, next.
Check. Is a valid sanction plan.
That's the problem, Mr.
Get hold of the Pradhan. He is in your favor. And tell him to come with the documents that it is a sanctioned plan.
And I annex the document. Sanction plan.
That is sanction is given. That is of the sanction has to be renewed and approved. That has been done.
I think,
All right, come next. Yes, next.
Milord, I appear in support of the appeal. If you see the cost type,
Respondent number 1 and 2. I'm led by Mr. Anil Bandre.
if you see the cost title, this appeal, this was a writ petition of 2012. Now, Milord, no interim order was passed in this matter. Matter was kept pending. I filed my opposition in 2014. Eastern Coalfield Limited filed opposition in 2014. Then, Milord, matter was appearing several days before Justice Saraf. Then, Milord, before Justice Shogota Rai.
Service is complete.
Service, they are appearing.
For the
Yes, they
respondent
are appearing.
respondent number 1 and 2.
Only
The writ petition.
Read petitioner. Milord, let me tell you what the permit.
Yes.
Yes. So, Milord, it was kept pending. First Justice Saraf, then Justice Shogoto Roy, Bhattacharya, had at length several days. Then Mr. Shaptangshu Basu was appearing. Shaptangshu Basu was appearing. Matter gets shifted to learned judge. Milord, also initially Mr. Shaptangshu Basu appears. And suddenly, Milord, at the last stage, the erstwhile advocate on record was Mr. Shaunak Mitra of Khaitan and Company.
For the writ petitioner.
For the writ petitioner, always. Then suddenly, towards the close, we come to hear that an advocate on record has been changed. And another set of advocate, he is constant, Mr. Anil Bandre appeared. And the matter was heard on two single days, and an ombudsman order of the West Bengal Regulatory Commission subsisting since 2012 was set aside. was set aside, and I say set aside on the ground of perverse reasons. Now, let me now tell you the history, then you will look at the order. My lord, various subsequent events happened.
What was the order passed?
As I will just. My lord, you will get it from the memorandum. You will get it from the memorandum.
That we have got order of the ombudsman.
I'll get it.
No,
Well,
what
therefore,
interim order you are seeking?
For that, my lord, that it's therefore, my lord, it's because of subsequent, I have to narrate these events from 2012 because it was subsisting in my favor.
Since 2011.
Yes, 2011 it was subsisting, and my lord, under that ombudsman order, some excess charge has been levied. Ombudsman has held refund that money. So, my lord, technically 18 crores is payable by them to me. And that has been for which I had filed proceedings for recovery, whatever, my lord, pending. So that's gone. Because the order of the ombudsman has been set aside. Now, my lord, two things I will say. First, my lord, there is, before I begin, because you never told us in the side, there is one small printing error in paragraph, and the clients had not said this, but while giving, they were not giving.
Yes.
Just, if you please come to page 5 of the stay application. The last 3 lines. Miller, it says, bank guarantee was continuing since 22nd September 2011.
Page 5.
Page 5.
Paragraph 2.
Yes, paragraph 1.
Page 5, we don't have paragraph. It's a part of the paragraph. Bank guarantee was continued. Yes.
Continuing. Since 2011, Malad, there should be a full stop. And in fact, is still continuing, was not what the clients, after approval, had given. But this, we didn't know because it had to be filed. This was added. So, Malad, it is not there. This portion, please delete. And you record my submission. It is a mistake by which this has been written.
So, bank guarantee is no longer...
No bank guarantee. Therefore, the question is, what is the bank guarantee about? You will want to know. Malad, now let me tell you what the facts are. The Shergor power, the Shergor, Malad DPSC, was owning 2 plants in Chinakuri and Dishergor. The Shergor plant was wholly owned by Dishergor DPSC. Wholly owned. Chinakuri plant was my plant. ECL land, we gave it on lease to them to run the power plant. By a lease deed of 1991 came to an end on 31st March 2011. 31st March 2011, thrown out in 2012. The dispute relates to Chinakuri only.
So this Chinakuri plant was under Dishergor.
It is ECL property. ECL, there's a lease deed records. The plant is owned by me. I have given it on lease to run for Milord 20 years.
Who was the lessee?
Milord GPSC. Yes. The plant. Now, Milord, what happened when lease was coming to an end? Various things were happening because they were clinging on. They started raising tariff, Milord, because electricity is generated by them from that plant and also distributed by them. Milord, like, for example, CSC is both a generating company and a distribution company. So electricity was being generated by them and also being distributed by them. They were generating from two plants, the Shergod plant, their own plant, and my Chilakuri plant. The dispute relates to only Chinakuri.
No, right, Mr.
Under the lease agreement, there is a clause that they will pay lease rental to me, but for supply of electricity, it will be governed by the tariff rate which is framed by the West Bengal Regulatory Commission. Because they are not only I'm the main consumer, no doubt about it. But the rate must be uniform. It's like saying, CSC charging one rate to someone, and because rates are always under the statute framed by the commission, regulatory commission. Now, towards the end, for the last leg, April 2010 to March 2011, the last year, for generation of coal, they need, generation of electricity, they need coal.
So the dispute is with regard to the rate.
Rate.
Now,
Except
Mr. Bose,
yes,
they charged you at an enhanced rate from the
Enhanced
Chinakuri
rate.
supply.
Yes.
So you put in the money for the rate which is
That was given.
that's given.
That was given. That is that. Otherwise, electricity was disconnected. So we put in the excess rate.
Not the excess, the agreed rate.
No, agreed to, but we have been paid. It's only claim for the excess which you charged. Ombudsman held you charged excess.
That is what was set aside by the learned single judge.
Yes. And after these whole years, when they have vacated the Chinakuri plant, I am now not drawing any supply from them from Chinakuri plant.
No, that lease has expired.
Gone, my lord.
2013.
In 2012, if your lordship wants to know, it's not the subject matter because it didn't happen. For lease rental, etc., these damages suffered because lease matter referred to Justice Nijjar for arbitration award.
No, we are not concerned with that.
No, that is important because Justice Nijjar says I
Where
cannot
is
pass
the order of
order
the
in respect of this because matter is pending.
Ombudsman order.
Ombudsman. Now, my lord, before I say that's one thing, so I told your lordship about the lease agreement.
Yes.
Lease agreement clearly says that for distribution and the rate charge.
To hear it, Mr. Bose, what
Yes, of course.
interim protection you want? There is
My
no
lord,
scope for
to be
any.
very fair, my lord, I will say about the interim protection. If there was my recovery proceedings have been it's been pending for a long time. So basically, there is no judge because if there was a bank guarantee subsisting, etc., I could have said that the bank guarantee will be in cash, etc. There is no bank guarantee. But yes, your lordship is right. What interim order of stay or whatever, please don't record my submission, but I think doesn't this particular matter has to be heard if you want on affidavit, otherwise on the basis of papers, paper book. My lord, only
But
one
Mr.
thing, please record that particular small deletion of the.
Mr. Bose, you file a one-page application seeking expansion of that statement.
But you record my submission, I made this submission. I will certainly that I made this and directly cite.
The present appeal.
Because, my lord, I have been asking my clients to file a supplementary. They're just not coming. So, but
Bose learned senior.
My appeal. May I have my lord's leave to file the
Pardon?
the stay application.
Stay application.
Yes,
What
and one.
interim order you want?
What has happened here is that during the COVID period, Railway Board came up with a circular saying that this period is to be treated as dies non, and depending upon the footfall and eyeballs at the railway station, for all these stall vendors and trolley vendors, if there is no restoration of passenger footfall, that number of days will be extended in their contract.
এটা কি আনতে পারবে?
But may I just
এখানে আছে কি? না তাহলে শুনবো না।
the questions in the past, no.
You have served the stay application.
But everything has been served.
Who is your other side? Railways.
To the railways. But by email also, as well as by hand service.
You appear for railways.
Not for the next matter, the following matter.
No,
Following matter.
But he
we
appears
want to see him in this matter. That is why we are asking.
Oh, very good.
You are in the railway panel. The application টাই তো আছে। আচ্ছা, we keep it tomorrow.
Obliged.
Take instruction and come back. The app.
I will.
your lordship directs the
ও আচ্ছা আচ্ছা, হ্যাঁ।
It's 30th April by email and 2nd May hand service. Because I've annexed the communications made to them in my affidavit of service. But on the first day when this act
Affidavit
was
of service as filed from Affidavit Any interim order you are seeking?
Yes, but I was seeking that what has happened. That's the reason why I was giving a
How much amount was asked?
no amount.
Then
This is a period of extension. I am only seeking that the entire Eastern Division, Millard, has many entire Eastern.
or let him come with instruction. Come with instruction. Yes.
Also my,
My lord, I am appearing for the.
this, may I have my one is earlier on, the earlier matter was pertaining to H. Wheeler. But H. Wheeler used to have book stalls. When we were small, we used
Similar to the matter.
no, they're not similar. But I would not say they're identical. It is within pertaining to the railways.
Do you have the instruction today?
Yes, he was Milanford appearing
In the trial
Alright.
court also.
Let us see in that. May I just give a brief?
Give us 2 minutes. Let
Sure.
us go through the order.
I'm sorry, Millard.
Stall is still there.
What has happened, Millard, is it?
So what is the?
I had a trolley.
Uh-huh.
I had a trolley. That trolley was to be a trolley which was not in a particular place.
So it was not a stall.
It was not a stall.
It was a trolley.
It was a trolley.
You are licensed.
Yes, Millard. I demonstrate on the document.
Then
Licensed.
so very good. They have not collected the dues from you due
Yes,
to the
they
COVID.
Affected by Millard, because the procedure is that
This is appearing tomorrow before the her ladyship.
there is no affidavits they filed till
David,
this
I'll
date.
time.
Till this date they have not filed.
It is
an
ready,
So,
Malak.
madam, why you have come up in appeal?
Millard, yes, the difficulty is that, Millard, that if Millard sees the order, it says, may I place the order? Learned counsel representing the railways submit upon instructions that the petitioner was found to be occupying a space in Shialda railway station without any authority. So these were all the submissions made at the bar. So with regards to this first statement, but I have demonstrated my writ petition from various documents that Kaushal Singh, the petitioner before my lord, was occupying, and they have been collecting rent from the very same person. Now, Millard, the second recording, and accordingly, the railway authority has removed the petitioner from the railway station without any step against me. No communication, no
So
notice.
you are not being allowed to run the trolley.
Yes, and because this trolley was under a single livelihood scheme of the railways. We will kindly have a look at this.
No, then why didn't you pay the amount?
Millard, yes, Millard, I will come to that. Millard,
How
the-
much is that? How much is
Sir,
that?
the procedure has been that whenever there was a certain amount which was fixed, till 2020, I have paid the amount. Thereafter, the procedure which was that the railways would give me a memo. I would take the memo and go to the desk, the counter. The counter used to take payment from me and give me a slip.
So very good, but
I have attempted numerous communications.
you are having no tea stall. You are not having a fixed stall.
No.
You used to run a trolley. Now let us understand. Now what they are doing, they are not allowing you to enter the platform. Since when?
Since this March 2025, that is when I come before the court. Now, kindly have a look at the photo.
So what interim order did you pray before the court?
They cannot do it without due process of law. They have to send.
So exactly that issue has not been decided.
Yes, but then
Wait.
they have not been. Well, kindly have a look at the photographs. Only
Madam,
use
let us. There is an order passed by the single judge. You are agreed that there is a refusal of my prayer to allow me to enter the platform. That argument was not advanced at all. Court said that I am seeking information, keeping it tomorrow, and you are agreed.
the difficulty is that this exercise of them seeking time to to put in their affidavits, which they were once given, will be extended. With my livelihood,
What is paragraph 3? Paragraph 3 of the learned single judge order.
Six times that he had come up with instruction on that day. On that
Paragraph 3, madam. Read it aloud.
Sorry, sir. The petitioner prays for an order restraining the respondents from closing the stall.
There is no fixed stall. What will be closed?
Yes.
It is not that you are not allowed to enter the platform. Go and tell that to the learned single judge that I am not having a fixed stall. I conduct my business by running a trolley.
Yes, look, the difficulty was that we had indicated to the. But it is not disputed that I run a trolley. Neither is it my learned friend's case that I run a stall.
No, but that's not what appears from the order, Michelle. It says stall. There's no mention of any trolley. And it will be a substantially different outlook once it's a trolley and once it's a stall.
Yes,
the difficulty is that I understand what is falling from my lord's that the
when you understand, you withdraw. Why you want your appeal to be dismissed?
Is it something which can be removed? Then why is it numbered?
Yes, but all these trolleys have numbers.
Yes, this is a trolley.
It's a trolley, my lord.
So you are not allowing him to enter because
Not enter. The fact is different, my lord.
What is the fact?
My lord, that is that the multi-purpose stall policy came in 2017. We have told them to apply. They have given only the affidavit, no other documents. And till then, they were unauthorizedly occupying the place.
They did not have any license. They had a license previously.
Had a license, but they have not paid since 2020.
So
and they have not opted for this policy also, where everybody has.
Let us understand. There are dues, and his license stands terminated. Did you terminate her license?
Not terminated. They have not paid. Thereafter, the new policy has come in 2017. So
no trolley can be run. What is the new policy?
New policy, trolley can be run, but they have applied, but without any documents, and not only his, but others also. So we have conducted a eviction process also, man. And thereafter, his trolley was removed.
May I just surprise the facts, Smith? Well, I understand what is disturbing my lord Smith, but then since my lord had asked him for his side of the story, may I just surprise the facts, Smith? I will
be deciding that once the single judge returns a finding, court has not returned any finding. And
the predicament is that this exercise of seeking time to file affidavits will continue.
Not that
matter has been made returnable on 8th May. Today we are on 7th. Tomorrow go to the learned single judge and this argument will be advanced. Then you will say that this is not, take the money from me and allow me to run the trolley.
We have been writing to them on innumerous occasions and there's been no reply from them.
We don't.
May I say this? May I take my chance once again in the coming week? And after the 8th.
After
the on 14th, if it so commences tomorrow.
The present appeal has been preferred.
Kindly, this individual petitioner is.
But again, they will go back there and say that appeal is pending.
There is no other source of income. There is just no other source of income.
No, but unauthorized
prejudge. Court has
not. That is the reason why my prayer is that we'll take this matter also on 14th. Till that time, we'll see what is happening there. If it so happens that the matter will, then I will come and.
That will be prejudicial to you. Once the learned single judge says.
Yes, sir. I appreciate it. Yes, sir. Yes,
so do you withdraw?
I will withdraw it.
We are not asking you to
Yes,
withdraw.
sir. Yes, sir.
তোমরা বলছো, তোমরা বলেছো।
Yes, sir. Melod is not asking me to withdraw.
Star learned advocate appearing for the
Never done.
Item number 9, madam, the Devanjan Banerjee is appearing for WPACDCL, madam, and praying for not today.
It is not the appeal of WBSCDCL, I should point out. The appeal has been preferred by the private respondent. I am for the writ petitioner, respondent number 1.
the appellant.
I'm not the appellant. I'm the respondent number 1, writ petitioner.
Is for the
I'm
appellant.
for the appellant, my lord. I'm praying for time, my lord. The advocate on record is not well, my lord.
Monthly list, yes. Monthly list দিতে হলো না রাখবে
I'm
এখানে
praying for
এই
my lord, not
সিস্টেমটা
this week, my lord.
মান্থলি লিস্টে তারপর তো নিতে পারবো না একজন গ্রুপ 9 থাকছে তো তাহলে একটা অর্ডার লিখে নাও এটা থেকে দিস ইজ দি ফার্স্ট টাইম ইট হ্যাজ কাম
The second time it was called on last week, my lord, once, my lord. Appellants had sought for time, presumably. Although, my lord, I was not present here.
My lord, the advocate on record is not
তাহলে
well,
এরকম
my
করো
lord. That is why I'm praying for
you
time.
also prayed yes last time also how many times you will pray what is the appeal about
My lord, the appeal is, my lord, the writ petition was regarding the disconnection of my electricity connection after it had been, my lord, given. And on the prayer of the private respondent, who are the appellants herein, the connection was so disconnected, my lord. And the learned single judge, my lord, the honorable single judge held that such disconnection was bad. And as it was not according to the law, my lord, there are certain grounds on which disconnection can be affected.
so it turned down the disconnection
Turn down the disconnection.
it has been given connection given to you
Connection is existing as per the instruction now.
connection is existing
At the moment, yes.
so sir
Has
you are a
been-
neighbor he is a neighbor
No, my lord. It is a little checkered, the history, my lord. They allege that
1 week after the vacation করে দাও তাহলে আর
It will
ওটা
fine.
লিখতে হবে yes next
Item number 10, my lord, I am appearing on behalf of respondent number 3, mother of the deceased boy. My lord, kindly appreciates on last occasion, probably on 1st of May, I was trying to place before your lordship that during
File
COVID, on 10th of July 2020, a minor boy of 17 years, my lord, he died practically on the footpath without getting any medical help from any hospitals. And my lord, this appeal has been preferred against the order passed by the honorable single judge stating to
Who is
pay
your-
rupees
who
5
is
lakh.
the appellant
Yes, appellant is Midland Nursing Home.
My lord, I appear for the appellants, my lord. My lord, I'm being led by Mr. Shubir Sanyal, my lord. May I pray for a short passover, my lord?
ask him to come yes
Yes.
show us the order
My lord, kindly comes to the,
you are there sir
my lord,
you are the advocate on record
No, my lord, I'm not the advocate on record, my lord.
Junior
I'm-
of Mr. Shan.
Yes, my lord, I'm acting as his junior.
What is your name
My lord, Soham Sen, my lord.
so very good you will argue
Very well, my lord.
And if we dismiss your appeal, we will call Mr. Subishan.
Very well, my lord.
My lord, kindly comes to the memorandum of appeal, page 164. My lord, kindly appreciates the West Bengal Health Regulatory Commission directed to pay rupees 5 lakhs to the family of the victim deceased. That order was challenged by the before the honorable single bench, and thereafter, my lord, honorable single judge also, my lord, from the order passed by the
Let us.
yes, my lord, page 164 onwards. Detail order, my lord, detail order. Grateful. এইটাই তো এই তো এখানে জায়গাগুলো কোথায় গেল
The appellant. Right.
সেটা
118 paragraph 3. 118 paragraph 3. 8 paragraph 3.
Where is the order of the commission?
Order of the page 872, my 72. Page 72, my lord. Operative portion is at page 83 onwards.
Aboni is the mother.
Yes, ma'am.
You are petitioner.
Responsible consumer. How much compensation did you claim
My lord,
for the commission?
5 lakhs commission passed an order of 5 lakhs, and that order was.
How much did you claim?
My lord, we did not claim any compensation because, my lord, initially complaint was lodged before Belghoria police station, and that complaint, my lord, was sent to the commission. Commission took cognizance and started hearing. If your lordship sees the last orders,
What is the jurisdiction of the commission as regards providing compensation? Any bar is there?
my lord, no bar is there, my lord.
That
As per
only
my,
you can deduct 10 rupees and not more.
my lord,
What is the cap?
my lord, ceiling, maximum ceiling. Probably there is no ceiling, my lord, no ceiling. My lord, he is appearing for commission. Page third,
You have brought yourself, not the book. বইটা তো নিয়ে আসতে হয়। Yes. Oh, wow, expensive.
Well, shall I read, my lord? Shall I read loudly? Oh, without prejudice to the other provisions of this chapter, if any
Give the name of the West Bengal Regulatory Commission.
West Bengal Health Regulatory West Bengal Clinical Establishments registration.
He's taking it out. West Bengal
Clinical Establishments within bracket Registration, Regulation and Transparency Act 2017.
ওটা আনো একটু ওইটা সংলগ্ন কি একটা রুলসটা নিয়ে সেকশন 3
Section 33.
33.
Yes.
What does it say?
My lord, without prejudice to the other provisions of this chapter, if any clinical establishment, whether by itself or by any other person on its behalf, while providing services causes injury to the service recipient of or his death due to negligence or any deficiency in providing service, it shall be lawful for the commission on substantiation of charges to direct it to pay compensation to the victim or the legal representative of the victim a sum A, which may extend to 3 lakh rupees in case of simple injury, B, which may extend to 5 lakhs rupees in case of grievous injury, and C, which shall not be less than 10 lakhs rupees in case of death, provided that the compensation shall be paid at the earliest and in no case later than 6 months from the date of occurrence of the incident. Provided further, in case of death, an interim relief shall be paid to the the kin within 30 days of the incident. Number 2, subsection 2, where any person is held guilty of a contravention leading to grievous injury or death, the commission may cause the name and place of residence of the person held guilty.
That is not true.
No, my lord.
Commission proceeding is still pending,
No, my lord.
disposed of.
Yes. Initially, my lord,
Where do we find disposed of?
page 43. Page 43.
Page 43. Commission order of
Sorry, sorry, ma'am.
24th September 2020.
Yes, yes. Interim relief was given, that order was final because they did not
24th
appear.
September, 10 September order is final.
No, subsequently, my lord, subsequently it was final. Page 85, page 85. Page 85.
So it was first order was passed on 10 September.
My lord. It was finally judgment passed on 22nd May 2023.
May 2020. It was finally disposed of after 3 years.
My lord, because my lord, on several occasions they came before Honorable High Court to pay the interim order which was passed by the clinical establishment under Clinical Establishment Act. Thereafter, my lord, finally
challenging what they came.
my lord, challenging the order of interim relief, before Justice Honorable Justice Ajay Kumar Mukherjee.
Where is the interim relief was granted?
Rupees
on
5 lakhs, same.
10th of September.
Yes, that was not paid.
Yes, Mr. Sonar.
Yes.
Not only that, my lord, their lawyer also did not appear.
I have been released for 10 minutes because the honorable judges have rose for the division bench only for 10 minutes to take tea.
So we will also rise up.
Normally, I do not find your losses bench. So that's why we prayed for that. This matter is continuing from morning. I have a little submissions. Give me tomorrow morning 10 minutes. I will do that. Then your losses decide. Do that. I will be coming back with your losses.
My lord, kindly comes to page 79.
Tomorrow morning.
Before the clinical step, before the commission also, they did not appear. Chances were given.
Mr. Chatterjee, make a list of dates.
My lord, we have prepared one affidavit in opposition. Shall I?
Opposition to what?
My lord, opposition. But against the stay application of stay, my lord, stay of operation.
That shows my lord stay should be granted.
Stay is there. Since the death of the boys, there is stay. On every
opposition, why you are using? We are not.
My lord, all right.
Ask your junior to tabulate the dates. Date occurred. When was the police complaint? When was the commission complaint? Just short.
Tomorrow we shall submit, my lord. Sure. My lord, what happened? They, my lord, prepared one COVID kit report, which they should not prepare. They should not have prepared that report.
We will hear you.
My কালকে সময় পাবেন
লাগে না যে গ্রামে যাবো সেখান থেকে
How long will you take, Mr. Sir?
But I think 15 minutes I will take.
এটা কি মোশন
দুবার
তবে তার আগে
তাহলে এটা কি বলে একটা নাম advocates we will hear you and finish it off.
Grateful, my lord.
Finish me, my lord.
My lord. Attributability must be there.
Obliged, my lord.
In this matter, I am appealing on learned ASG is unwell, my lord. I have been requested to pay for accommodation of not today and tomorrow. My lord, kindly take it on Tuesday, my lord, 13th.
পেয়েছো এই ফাইলটা পেয়েছো না না next 12 এটা কোনটা you are there other side
will take serial number 15 because
একটা কপি থাকে তাহলে
serial number 15 টা দিন 15
come tomorrow My brother has a bench, so we will be rising a bit early. Tomorrow, all right?
No. Yes, tomorrow one matter is fixed at code number 37.
No.
Only one, two matters are there.
The next Thursday.
Next Thursday. My lord, only request is, my lord, there's one common order in all the matters. My lord, I am appearing for item number 13 and 14. One common order. My lord, if my learned friend gives me the copy of item number 15, so I can be ready on this.
So Das wants to submit on 15.
Yes.
No. Who is there any
Instead of Thursday, make it Monday, Miller.
Monday,
Friday,
covered Monday.
Sorry, Tuesday.
Tuesday. Well, it's an interpretation of the tender condition, subject to condition, fixed rate contract. It's a tender condition, well, whether the tax
now anybody has been given the bid.
No. Work
Tender
has
process
been given, has been executed, only refund of sum of money which has already been paid on account of the GST. This is an issue pre-GST, post-GST regime.
Previously?
Initially, there was a tender. I participated in the tender, found to be lowest. I have been awarded the work. I have executed the work. Work has been executed prior to promulgation of the GST. Subsequently, few running account bill has been paid in my favor on the basis of the VAT quantum. Subsequently, few running account bill has been paid after the promulgation of the GST, where Miller I have to pay 12%, which I am not aware. I have participated in the tender, keeping in the mind that I have to pay 3%. I have quoted the rate on the basis of which.
Single judge say? What did the single judge say?
Single judge says that, Miller, that cannot be done because if I allow your application, in that event, there would be a revision of rate.
No. Terms of condition, because it
This
was
would be a revision
the
of
price,
it has
the
been stated
basic,
over there.
the
So
basic.
in the original contract, question of incorporation of GST didn't occur because GST was not implemented.
Subject to correction, the question was subject to
And
correction.
there is a particular language which has been used that the intending tenderer will quote the rate considering the taxes which have been mentioned.
Date.
Yes. That date has not been mentioned.
On that date.
Considering the
On
previous
that date.
Yes.
On the date of the tender.
2014.
On that date,
Alright, next Thursday.
the issue was subject to correction. Issue was
Instead of Thursday, make it the Tuesday or Wednesday, any date convenient to your lordship.
Then let it be on 19th, Monday. 19th, yes. Next week. Same.
My lord, I beg to appear on behalf of respondent. The state authority has preferred this appeal. My lord, this is relating to payment of pension. My father died in the year 1981. Since then, my lord, I am not getting pension.
You are an employee under?
Under Health Department, Government of West Bengal.
West Bengal DCRB rules are in
Yes, my lord. Yes, my lord. And my lord, the single judge was kind enough, writ court was kind enough.
Who's your other side?
Mr. Abu Talib and my lord Siddiqui. My lord, my lord, Mr. Siddiqui, my lord, the senior advocate. Let a copy though. This lordship was kind enough to direct me to file compilation.
Yes.
Of document. While entertaining their application.
You are the son.
Yes, my lord, son and daughter praying for family pension. My lord, we have applied for compassionate appointment. The file was moved.
Family pension not given.
Not getting. At the same time, my lord, to move for my compassionate appointment, it is a three-man committee was constituted. Committee has placed his report. Then, my lord, no further development. At a point of time in the year 2015, it was rejected on the ground. Since you have passed, my lord, the lapse of considerable period of time, you are not entitled. In the year 2015, that has been rejected.
That you have challenged.
My lord, so far compassionate appointment, meanwhile my age has been increased. My lord, so far the family pension and other things are concerned. My lord,
is there any paper?
My lord, the compilation direction was there. This is a compilation. And my lord, our only predicament, my lord, we are in spite of all effort, I am yet
the order.
But in spite of all effort, I am not in a position, my lord, to supply effect service upon my learned other side.
Have you brought the Supreme Court judgment?
My lord,
what charged employee you have brought the judgment?
Once a?
What charged?
My lord. My lord, that was not with me, my lord. I am placing, my lord, page
So
70.
you are not a permanent employee.
Permanent employee.
You are not a...
Otherwise, my lord, compassionate appointment related file cannot be moved.
That is a separate issue.
True, my lord.
Where have you, which document would show that you are a permanent?
My lord, my document I am showing, my lord, at that point of time in the year 1981, our age was...
Place the order impugned first.
My lord,
where is the order impugned?
My lord, I'm coming. 218, my lord.
74 is the order.
My lord, that is order of the Honorable Reed Court. Yes. I'm placing.
21st of August 20.
My lord, I'm placing, my lord. The petitioner are the heirs and legal representative of the late Shochipati Ghatok. The petitioner number 1 is the son of said petitioner, and the petitioner number 2 is the daughter of the said deceased. Late Shochipati died on December 28, 1981. It is alleged that during his lifetime, the said deceased was an employee, being an ambulance driver of the Katwa Subdivisional Hospital.
So was the relevant portion now.
Kindly come to my lord. My lord, I'm coming on page 81. Page 81, my lord. Page 80, my lord, the bottom, last paragraph. Paragraph 18.
18.
The doubt arises as to whether Shochipati's service continued after May 18, 1965 till his demise in date December 1981. There are two indicators in the material on record which favor the petitioner claim that Shochipati's service had continued and he had died in harness. The first is that communication by the Director, Department of Health on 2nd August 1984 to the COMH Bardhaman, which indicated that the deceased Shochipati, an ex-ambulance driver of the Katwa SD Hospital, had indeed died in harness, annexure P3 at page 18 of the writ petition. Secondly, in reply to the Member Secretary of the West Bengal Women's Commission, the Joint Director of Health Service to West Bengal wrote on May 28, 2015 that compassionate appointment prayer of the petitioner was rejected in view of the delay in filing the same. In the same breath, observing that Les Shochipati was an ex-employee who died in harness on December 28, 1981. Then, my lord, paragraph 20, the petitioner who are quite young at the relevant juncture when Shochipati was in service and even when he met his demise cannot be expected to be in custody of relevant paper regarding the service of Shochipati. My lord, turn to next page, my lord, paragraph 21. In so far as burden of proof is concerned, it is the employer Shochipati who ought to have special knowledge regarding Shochipati's continuance in service with the said employer or otherwise. Section 106 of Evidence Act provides that when any fact is specially within the knowledge of any person, the burden of proving that fact is upon him. In the present case, special knowledge lies with the employer. Since the matter concerns service of an employee, the heirs of the deceased employee are not expected to carry document regarding such service. The liability of the employer to produce service record all along, at least since 1983, cannot be justified in any manner. As per Section 106 of Evidence Act, the burden lies on the employer having special knowledge to produce such document, in the absence of which adverse inference may very well be drawn against the employer. Section 114 of the Evidence Act provides that the court may presume the existence of any fact which it thinks likely to have happened, regard being had to the common course of natural events, human conduct, and public and private business in their relation to the facts of the particular case. Illustration D under Section 114 is that a thing or state of thing which has been shown to be in existence within a period shorter than that within which such things or state of thing usually ceases to exist is still in existence. Shochipati's service was admittedly continuing at least till 18th May 1965. In normal course of things, the said service would continue, my lord, turn to next page, subsist till his demise in 1981. Since it is the employer who insists that the same deceased within a period shorter than that, the burden lies on the employer to establish that Shochipati was terminated or retrenched or left service prior to his demise. In the present case, such proof is entirely absent, and the respondent authority seeks to wash off their hand on the flimsy pretext that the relevant records are not available.
But
the
why
ground
did
of
you
delay
approach
cannot.
them so late?
My lord, because of
81 he expired.
Initially, my lord, the file for compassionate appointment moved.
So you didn't claim pension at that time?
Claimed, my lord, but not processed. Initially, my lord, the wife has claimed it.
81 died.
Lordship.
Writ petition filed in 2022.
No, my lord, what happened? Went to the, my lord, the
Your right to get pension arose on the date of
Yes, my lord.
date
Yes, my
subsequent to the date
Yes,
of
my lord.
death. So how you are explaining that fact?
Protracted history of litigation, initially state administrative tribunal. Initially, my compassionate appointment was rejected.
You did not pray for family pension at
Yes,
any
my
time?
lord. Thereafter, I had to move.
Show us.
I'll. Lordship, kindly
Finish
come
it
to
off and show us.
kindly come to my lord. After the rejection, page 33 may kindly be looked into.
Family pension card. Now your deceased wife has also expired.
Expired.
তাহলে তো দোষ।
Only, my lord, that at that point of time, minor.
Now family pension is not.
No, my lord, the minor daughter.
Do you have any daughters?
Yes, my lord. My lord, kindly come to page 34. My lord, this is a communication.
Page
34.
You finish it up. What more document? What you are saying? So one is Evidence Act.
Yes, my lord.
Next. Very good. Then what is the
And number of other documents are also there, my lord. I will show.
Para 28.
Para 28.
He was terminated prior to statute.
Coming, my lord. Para 28, my lord. In the context of the above discussion, it was for the respondent authority to produce the record either to show that Shochipati's service was continuing or that the same was terminated prior to its natural tenure. Having failed to do so, adverse inference has to be drawn against the respondent authorities. Accordingly, it is presumed that if the records are produced, the same would operate to the detriment of the employer interest. Hence, in the absence of any material to show that late Shochipati was ever suspended, retrenched, dismissed, or retired from service before his death, the petitioner are definitely entitled to the entire pensionary and retirement benefit due on the demise of their father, my lord, the late Shochipati Ghatak, the employer and ambulance driver with the Katwa SD Hospital, Bardhaman, on his demise on December 28, 1981. Accordingly, WPS so-and-so is allowed on contest, directing the respondent number 7, the Special Officer Pension Government of West Bengal to disburse the entire retirement pension benefit of late
So
Shochiputi.
no service book was prepared in your respect.
My lord, pursuant to the direction of the Honorable Reed Court, my lord, it was duly prepared. Then finally, my lord, when they have filed, they went to my house and it was duly prepared. Directed me to supply certain papers and documents, and it was taken into consideration, prepared. Then, my lord, the state authority, my lord, health department moved this mandamus appeal and obtained this stay order, as a result of which, since then, my lord, we are in the dark.
So where do we find that fact that service book was prepared and placed before you?
My lord, I'm coming, my lord. My lord, that fact, my lord, because of it's my personal knowledge, they went to my house at Katwa and requested me to supply certain document for the purpose to facilitate preparing, my lord, the service book. That was the after the order when I filed contempt application before this honorable court in the Reed court.
Then what happened? You did not pursue the contempt.
Yes, my lord, we are pursuing contempt. At that juncture, they have moved this mandamus appeal and obtained this stay order.
Stay was obtained in 2024.
Yes, my lord. After a considerable period of time. After a considerable period of time, my lord, the contempt was moving.
Just show us the documents upon which you are.
I am coming, my lord. Lordship, kindly come to my lord. Page 23 at the outset, my lord. Page 23, my lord, to Chief Medical Officer Health by the Subdivisional Medical Officer, Annexure P1. Enclosed, please find with the application in respect of book.
Pension for on the date of date following the date of 81. When did your service period end?
My lord, we are continuing.
Continuing is what was your 60 years when you would have acquired?
My lord, subsequently, 81 I am died.
81 you died. You entered in 65.
Yes.
75, 85, 81.
81.
On the date of death, what was your age?
My lord, I'll check it. My lord, prior to superannuation. That is because
died prior to superannuation.
That is because compassionate appointment file has been moved. I will show, my lord. Kindly come to page 25. They themselves moved it. 3-man committee was constituted. Committee has filed their report. Because of they are, my lord, the
show us where they admit that you were a
I'm sure. Page 25, my lord. Kindly come to, my lord, Annexure P1. Page 23. Page 23, my lord, I'm reading. Enclosed, please find here with an application in respect of Srimati Bhakti Rani Ghatak, wife of, my lord, the Shochiputi Ghatak, wife of late Shochiputi Ghatak, ex-ambulance driver of this, my lord, hospital. In this, my lord, connection, I beg to inform you that Sri Shochiputi Ghatak worked in the hospital up to the date of so-and-so. As per record available in this office, he has been paid salary up to, my lord, 1965. He has on a deputation at Asansol LM Hospital. And it was written by the Subdivisional Medical Officer Katwa at that point of time on 14/8/1983.
He worked in that office up to 65.
Then, my lord, transferred to the LM Hospital of Asansol. Then LM Hospital of Asansol is not. I'm coming. Then, my lord, kindly come to next page. Turn to next page. Government of West Bengal, Office of Chief Medical Officer Health, Bardhaman. To the Director of Health Service, prayer of Srimati Bhakti Rani Ghatak, wife of late Shochiputi Ghatak, ex-ambulance driver at Katwa SD Hospital, for employment of her son on compassionate grounds. The following particulars of the above subject are forwarded herewith for favor of your perusal and taking necessary action in respect of employment of the son of deceased ambulance driver late Shochiputi on compassionate grounds. Prayer of Malad so-and-so, prayer of Kalachand Ghatak, son, admit card, the certificate from Gram Pradhan, family composition statement, Xerox copy of death certificate, mark sheet, etc. And this was forwarded to number of persons, including myself at the bottom, my mother, my lord, since disease, since Srimati Bhakti Rani Ghatak. Then Lordship turn to next page, page 25. File further moved. Prayer for employment of Sri Kalachand Ghatak, written by the DHS West Bengal. I am directed to request you to place, my lord, with your comments at a very early date, whether the disease late Shochipati Ghatak, ex-ambulance driver, Katwa SD Hospital, died in harness. Answer is yes. Page 25.
Where is the order of the committee?
Well, committee formation related papers are lying with us.
Then where is the final order?
Lordship, kindly come to page 28.
28 we have seen. That is the order of constitution of the board.
Constitution. My lord, that
Where is
final
the
order,
final order?
we are not aware, my lord. No appointment, no, we are not communicated that final order of the.
When did your mother expire?
Mother, my lord.
Actually, I don't know.
I'm coming, my lord. Then, my lord, kindly allow me, my lord, to read page 29 also.
Mr. Chakraborty, you have to show us 3 documents.
Lordship.
One, any document you have to show that you were in service, apart from these documents, where a statement has been made by the state that you had been an ex-ambulance.
They have made that statement, my lord.
That statement will not give you any right.
Lordship.
You have to show us any document. He must have got monthly salary. He must have had monthly slip.
What is more,
you are making your case, you yourself, you are making your case difficult.
No.
Show us any document from which we can come to the satisfaction that he was a regular employee.
My lord, kindly see, my lord, page 33. The Special Officer Pension Directorate of Health Service, what is written, my lord? To the address to the Superintendent Katwa Subdivisional Hospital, pensionary benefit in respect of late Shochipati Ghatak, ex-driver, Memo Swanso, inviting a reference to the above, you are hereby requested to furnish the latest development regarding disbursement of pensionary benefits
to Siddiqui. Where is Mr. Siddiqui?
Actually, due to his personal inconvenience, he could not come to the court.
Ask him to come and appear tomorrow. This will be in the list. Take it out, judgment. Come tomorrow.
My lord, may I be permitted to hand over the copy of compilation?
Take a copy. Give it to Mr. Siddiqui. Sure.
Deep down. Not to develop.
Entertainment. We have discussed your arguments. And you ascertain also whether any pension due was there or not. If so, the consequential portion you.
That is already in the order, ma'am.
We have already passed that order for your. Totally black. আরে কি যে বলো আচ্ছা we have সই করবো এগুলো নেই না
এই আর কোনো ম্যাটার হবে না বাথরুমে কি বসে নো মোর ম্যাটার ম্যাম
my brother has a bench
ওয়াই
এই আমরা তো পিটিশনার, তাই তো আমাদের ওইদিকে যেতে হবে।
for age, যা পাচ্ছে করো।
এই সব ইয়ে ওই দেবব্রত রায় আছে। You are placing from which paper book?
But I think there is only one paper book.
No. One appeal by the board. One appeal by the board.
You are the appellant,
Where I am the appellant.
so you have to be on our left hand side.
Oh, your left hand side.
No, let it be changed.
No, that photo.
হ্যাঁ ওটাকে দিয়ে দে।
যেটা একটু বললাম স্যার।
আচ্ছা আমার একটু ছিলেন গান দেখতে ছিল।
You are placing from which paper book, Mr.
Milord MAT 873.
873.
873.
It is bottom.
But it's item number 21 in today's list.
Yes.
সকলে বসার কোনো ইচ্ছে নেই।
কি শুধু আমার চেহারাই দেখা যাচ্ছে।
Yes, Mr.
Milord, in this appeal, Milord, the board is before the appeal court, Milord, challenging an order passed in a writ petition, which was filed by 140 writ petitioners, Milord, challenging Milord, a recruitment process, Milord, which was initiated in the year 2016 by the West Bengal Board of Primary Education.
Yes.
Milord, I would like to, Milord, take your lordships first through the writ petition before, Milord, placing the judgment under appeal, because we have got a lot to say about the confines of the writ petition and, Milord, how it has been expanded, Milord, contrary to, Milord, all the procedures that, Milord, are available, Milord, in the judicial system.
Yes.
But if your lordships may kindly take the writ petition, which starts at page 36. But I am starting from internal page 28 of the writ petition after the cause title.
Appellant is board and its chairman. Its functionaries are there.
But board president and secretary.
All right. Yes.
But unsuccessful candidates are before the High Court in the writ jurisdiction. Please take, Milord, page paragraph number 3 onwards. Your petitioner states that on 19/10/2012, the West Bengal Board of Primary Education published notification for recruitment of assistant teacher in primary schools. It is needless to say that there were huge irregularities in TET 2012 and several cases were filed. In spite of irregularity and illegality, 18,000 teachers were recruited, and Government of West Bengal gave one exemption to the aspirants of TET 2012, that the aspirants of TET 2012 can sit for the next examination, and in that case they shall be exempted from paying any fees for the examination. The petitioner states that on 12/11/2014, NCTE published a notification dated number so and so, and in that notification, qualification and other procedures for recruitment were prescribed. Para 5, your petitioner states that on 9/4/2015, Ministry of Human Resource Development published a notification under so and so dated 9th of April 2015, extending some relaxation to the state of West Bengal till 31st of March 2016. Your petitioner states that on 14/7/2015, Government of West Bengal published a notification framing certain rules disclosing about the requisite qualification, etc. Then 7 is, your petitioner states that on 11/10/2015, TET 14 examination held in West Bengal, where huge number of students appeared. It is needless to say that on the date of examination, the notification issued by the MHRD was in force, and all the students who passed and or qualified in TET 14 should get benefit of the notification of 9/4/2015. Your petitioner states that on 2/3/2016, the recruitment rules of 2016 was notified, and Rule 6 of the notification speaks about qualification of persons who are seeking and or eligible for appointment. In clause 6, subclause 3, some specific guidelines are there for non-trained teachers. It is needless to say that all TET 2014 candidates are entitled to get benefit of this instant rules and the notification issued by MHRD. Your petitioner states that on 14/9/2016, the result of TET 2014 was published, but no merit list and scorecard was given to anyone. On 26/9/2016, notification was published for appointment of primary teachers from TET 2014 to fill up 42,949 vacancies. In that notification, it was clearly stated that candidates with minimum qualification as specified by MHRD will get preference, and after that, eligible candidates with relaxed qualification may be considered. Or in other words, Millard, first the trained candidates will be appointed, and for the rest of the vacancies, untrained candidates. That was the relaxation. It is needless to mention that MHRD gave relaxation only till March 2016, and in spite of that, the board notified that the candidates who do not have the training will be considered too. The notification proves that the board decided to give something of the relaxation benefits of relaxation to all TET 2014 qualified candidates. Your petitioner states that after the notification, the procedure was started for appointment from October to December 2016. The interview and verification started on 31st of January 2017. Allegedly, the merit was declared, but there was no panel, there was no merit list, there was no category-wise, merit-wise, no division of numbers, and or rank was given to anyone. In website of the board, there was a dedicated space where the person could see whether she was impaneled or not. No merit list was ever published, and in spite of repeated requests, the full merit list was not made to the public. Allegedly, it was stated on 31/2017, list of trained candidates were published. On 4/2/2017, list of non-trained candidates other than the Bengali medium was published, and on 8/2/2017, list of non-trained candidates and candidates from Bengali medium were published. From the dates and the list, it is clear that all trained candidates of TET 14 were appointed through the first list, and after completion of the same, as per notification of 2nd March 2016, the board appointed non-trained candidates. The board stated that they shall publish more lists, but those lists were not published. Your petitioner state that on so-and-so date, notices were published for recruitment as assistant teachers in primary schools from TET 2014. The board has appointed non-trained teachers after 2016 even, and intentionally ignored the petitioners by giving excuse of notification of MHRD by way of so-and-so dated 9th of April 2015. Thousands of non-trained students were appointed, and petitioners, those similarly placed, were ignored. But this is the only case. Petitioners who were similarly placed were ignored.
They were also non-trained.
Untrained candidates or non-trained candidates. Untrained. If it is the stand of the board that no non-trained candidates can be appointed, then all the appointments of non-trained candidates made after March 2016 are bad in law. The relaxation given by the NCTE is applicable to all in any TET 2014 candidates who qualified in the examination.
So they board appointed untrained candidates. The petitioner says that I am also an untrained candidate, but you have not included me.
Included me, or you have given, deprived me and given appointments to other non-trained candidates. But this is the short case. Now, this has been stretched to, I should say, my lord, and illogically extended, my lord, adjudication of the matter. Your petitioners state that recently the TET 14 scam busted in West Bengal, and from several cases lodged by CBI and from several orders passed by this court, the petitioners came to know that several illegal appointments have been given by depriving the petitioners. Non-trained candidates are the worst sufferer of this scam. On 23rd December 2020, the West Bengal Board of Primary Education published one notification of recruitment of 16,500 primary teachers. This is the subsequent recruitment process. I don't think I need to trouble your lordship with this part. Then 13, Millard, they give examples of 4 persons who were allegedly non-empaneled, but they got appointment. And then, Millard, kindly take, Millard, paragraph 14. Your petitioner states that at present, there is more than 1 lakh vacancy in the education department. Since 2011, several examinations were conducted to fill up the vacancies in the school, but a single recruitment procedure could not be completed without corruption and irregularities. The qualified students were not selected. These are all prejudicial facts. Then, Millard, paragraph 15 is, Millard, one honorable member of the parliament had made certain comments. The others are MLAs who have made certain comments. Then paragraph 16, biggest scam, TET 14 is the biggest scam. Para 17 again, TET 14 is the biggest scam, and 14 to 20 lakh rupees were exchanged. Then kindly take, Millard, para 18.
So you were unsuccessful in TET?
The writ petitioners. No, they were successful in TET, but as your lordships know, Millard, TET is a qualification for applying as for recruitment for the
So they passed TET.
Yes, so far as passing of the TET examination is concerned, there is no dispute.
Now they are saying that TET
that they have been, yes, what their case is that they also fall within the untrained or non-trained category.
Who were not successful in TET?
No. Everybody are successful, because unless somebody is a TET qualified, like I can apply for enrollment only if I pass the LLB degree course, or I can apply for judicial service provided I pass the LLB course. So therefore, TET is like a qualification, isn't one of the eligibility criteria. Your petitioner states that the board has started different cases before this court, that 42,897 candidates were selected till date, but no merit list of the candidates were ever published by the board. The board should be directed to publish a merit list by disclosing the numbers obtained in written interview, and a reservation category-wise list should be published. Candidates were informed through SMS, and no merit list of so-and-so candidates were published, and it proves the mischief in the recruitment process. If the process was free from all corruption, then there ought to have been a transparent merit list of so-and-so. The process was not completed in February 2017, and the department is well aware of the same, and this honorable court should take notice of the same. Persons who did not qualify for TET 14 were appointed as primary teachers, but these are all Millard submissions without any proof whatsoever, any evidence whatsoever. Be that as it may, I will deal with each of the allegations. Were appointed as primary teachers by the board, and in spite of specific case, steps were not taken, and it shows that there was corruption and illegal financial transaction while conducting the recruitment process. The department ought to have given suo motu steps, but that was not done for the reasons best known to them. Moreover, many candidates complained that TET 14 qualified candidates were not issued to them, and even today they were fighting for that. There is no delay in filing the PIL, etc. I do not know from where, Millard, they have copied this, but this is there. Then, Millard, para 19. The petitioners state that your petitioners are hailing from poor families, and if they were recruited in time by giving them opportunity of being trained, etc. I don't think that these are that important. Then para 21, 22, they all speak of corruption everywhere, and then are the grounds. Now, what is very, very important is the prayer and the date of affirmation of the writ.
So you tell us what was their pleading based, what were the arguments they were advancing?
Milord, I can speak of the argument provided, Milord, the proceeding was confined to or limited to the pleadings, and Milord, the affidavits in opposition and the replies.
And according to you,
yes,
what
there
are
was
the
no argument.
What were the contentious issues?
Milord, there were no argument. Now, Milord, I'll place the judgment. There was no argument.
No,
But I would start from placing judgments before this court, that what is meant by a judgment and what should be the characteristic of a judgment.
No, according to you, Mr. Dotto, on the pleadings, what were the infirmities they pointed out?
Milord,
one was untrained, similarly situated, not.
But this is the only part.
No merit list was published.
No merit list, Milord, that Milord, I'll satisfy, Milord. Yes.
Third is there are discrimination among certain persons.
3 or 4 examples were given. 3 or 4 examples given.
So primarily it is think that I am unsuccessful. Yes. So you turn down the entire.
No. That was not the prayer. That was not the prayer. Now please have a look to the prayer. But I will take your Lordship, Milord, from the very first order which was passed in this writ petition. But this matter has, Milord, very many facets for your Lordship to decide, in addition to the merits of the matter. And
it has not come up in appeal against
no, because the entire recruitment process is conducted by the board.
State is also
Conducted by the board.
Yes, show us what you are showing.
Yes, now kindly have a look to the prayers. 47. At page 47. Prayer A is Rule 26 dispensation. Prayer B. A writ of in the nature of mandamus be issued directing the respondent authorities as follows: to act in accordance with law, to direct the authorities to file a report disclosing name, numbers, rank, category of all non-trained candidates who have been recruited till date in primary schools from TET 2014, including the date of recruitment. To direct the authorities to treat the petitioner equally with the non-trained candidates who have been recruited by the board after expiry of the relaxation given by MHRD on so and so. To recruit the petitioner by giving them the same benefit by which the other non-trained candidates were recruited by the board by following the rules dated 2nd of March 2016 and appointment notification dated so and so. Direct the authorities to publish a merit list by maintaining full transparency regarding TET 2014 recruitment to protect the records, etc. Sasur, right. And Milord, in this writ petition, Milord, 36,000 appointment has been set aside without any prayer.
Yes.
The date of affirmation is very important. 12th of September 2022. In respect of a recruitment drive in the year 2016.
When was the last appointment made?
Last appointment
2017. Apart from please ask your junior to.
Yes, 2017 February. But in addition to that, Miller, there are certain court orders. Under court orders also appointment made, but
subsequent to 17.
Subsequent to 17, but these are all under court orders. But so far as the board is concerned, in the recruitment process, the last appointment was made in February 2017.
Recommendation.
Or recommendation.
Yes.
Now, Miller, I need to, Miller, take your Lordship, Miller, through the orders passed by the learned single judge from the day of entertaining the writ petition. But judgment period under appeal, Milord, I'll come later on.
Yes.
Milord, your lordships may kindly take me the third paper book, page 418. আচ্ছা আমাকে পেজ নাম্বার গুলো বলে দিতে হবে। ছয় দুই বাইশটা কত তারিখ? কত পাতা? 6-2-22
418
6-2-22
415
415
তুই আমাকে 6-12-2022 পাতাটা বল। Please take me to page number 415 first. This is dated 6th of December 2022.
Yes.
The petitioners appeared in the 2016 recruitment process. All of them are TET qualified, as has been submitted from the bar and pleaded in the writ petition application. The petitioners came before this court after the documents and marks produced before the division bench, headed by the Honorable the Chief Justice, in one of the matter which was first moved before me, and I adjourned the matter, seeing the nature and character of the same as a PIL, and sent it before the Honorable the Chief Justice.
This is not the writ petition against which this appeal is coming.
Yes, this is the writ petition.
No,
the one which is referred is another. Yes.
Then why we are going into
No, this order is passed in this writ petition. 6th of February, December 2022, this order is in this writ petition.
this is this appeal is arising out of 21187.
Milord, these are.
What is your writ petition number? This
WPA 21187 of 2022.
So this is your their writ petition.
Their writ petition.
This is the first order in that.
Yes, it's in fact the third order, but the previous orders are not that important.
Yes.
Then, Milord, the next paragraph is the petitioner has come to learn that in 2016 recruitment test, a large number of untrained candidates were given recommendations and appointments by the West Bengal Board of so-and-so and the respective councils. The petitioners given said a large number of candidates were appointed who got marks below the petitioners. The petitioners got this information from the learned advocates who inspected the concerned list. The petitioner submitted despite their marks being higher than the untrained candidates of 2016 and were called in interview and aptitude test. None of them were called in the interview. Learned advocate for the West Bengal Board of so-and-so has drawn my attention to the prayers and have stated that in one prayer the petitioner has prayed for publication of some information which are already in public domain. But I am told by the petitioners that the petitioners' breakup of marks are not in the public domain, as the candidates who were recommended, only their marks have been uploaded. Learned advocate for the board has also raised the question as to whether the petitioners applied for the recruitment test of 2016 and whether they were called for interview at all. After considering the submissions of the parties, I direct the petitioners to disclose the application filed by the petitioner and call letters for interview of the petitioners by filing supplementary affidavit. The petitioners shall also disclose the documents as to their training qualification, if any, taken by them. The training qualification documents, if any, shall also be disclosed. Or Milord, the court is inviting documents from the petitioners. Why this is important, Milord, as I progress, your lordships would find. Kindly take the next order of 20th of December 2022 at 418.
Yes.
The case of the petitioner in short is that though the petitioners got higher marks before addition of marks against interview and aptitude test, comparing to some of the candidates who have been given the appointments against 2016 recruitment process ever after adding their marks for personality test and aptitude test, they have not been given appointment. Please mark this last sentence of the court. The petitioner's case is that interview was also held, aptitude test was also taken. But why this is important, I'll come later on, because the judgment proceeds on the basis that no aptitude test was taken and the honorable judge had called witness, cross-examined the witnesses. A complete unknown procedure. Allegedly in exercise of power under section 165 of the Evidence Act. But please mark this sentence that it is the case of the petitioners that adding the interview marks and aptitude test marks given to them, they were not given appointment. This is the recorded case. Though, my lord, it's not there in the writ petition, I had placed the entire writ petition before your lordships. They have come before this court as have been submitted after taking inspection. I'm sorry.
Though the petitioners got higher marks, this is higher marks on which evaluation? This is prior to the interview.
No, but after completion of the entire process, according
Said that though the petitioners got
higher marks
before addition of marks before interview and written.
Yes.
So prior to this interview and aptitude test, there was any further rider?
Milord, as your lordships know, Milord, there are certain marks for academic qualification which is added. These are those marks which upon addition
of academic qualification, they got higher marks.
This is their case. But what is very important over here is that finally, Milord, the Honorable Court has not gone into this. The judgment which is under appeal before your lordships proceeds completely on the basis that no aptitude test was taken, therefore entire process is bad. I'll come to that, but this is very important. How, my lord, the stand is getting changed from time to time. Therefore, my lord, the first positive assertion is recorded in the order of 20th of December 2022. They have come before this court as has been submitted after taking inspection from the records produced before the Honorable Chief Justice's court in a public interest litigation, and they have also got some input from the publication of marks of the M-panel candidates. In respect of WPS 1, so the present one, the petitioners have prepared a tabular chart of 139 candidates, and the petitioners submit that all those 139 candidates have got higher marks than the last employed candidates, but they have not been given appointment. Pausing here for a moment, this point also I will be taking that these tabular statements, my lord, are not pleadings. There has been no amendment of the writ petition.
Yes.
Mr. Ratul Bishwas, learned advocate for the board, prays for some time to check the marks of so-and-so, making appropriate submission so-and-so. For this purpose, I fix so-and-so. Along with the matter, such and such are being moved, I direct so-and-so in for application to supply similar tabular sheets to Mr. Bishwas, and Mr. Bishwas will come after verifying. Mr. Bishwas is also directed to come with particulars of the tabular form, etc., etc. Then please take, my lord, the next order. This is very important for me. 17th of January 2023. Kindly similar the turn of events from here. But as I said, my lord, your lordships.
Yes.
But I would invite your lordships not to only confine to the merits of the judgment. The procedure which has been adopted in the adjudication of the instant writ petition is very important, my lord. Otherwise, my lord, for the future, my lord, this will remain in the records of the Calcutta High Court.
Page, which
page? Page টা বলতো?
Page 421.
Page 421, 17th of January 2023.
Yes.
In course of hearing, A serious allegation was made by the petitioners that in the selection process of 2016, when the stage of interview and aptitude test came, only interview was taken and there was no aptitude test. Though in aptitude test there are 5 marks are there also for interview. Completely contrary to the previous day's Millard recording. Please come back to Millard, the previous order.
Both were held.
Both were held, marks were added, and thereafter people who got lesser marks were appointed, petitioners were deprived.
Herein they say that there was no interview.
No aptitude test. Interview was taken, but there was no aptitude test. Though in aptitude test, there are 5 marks. Or under the rules, Millard, for aptitude test, Millard, 5 marks are allotted. Interview 5 marks, aptitude test 5 marks. So a completely contrary case. I do not know who has made out, but it is recorded. Now kindly see, Millard, the Honorable Court takes upon itself the power under section 165 of the Evidence Act. As a large number of petitioners were present in the courtroom, this is the reason. So many petitioners are before your lordships, therefore, Millard, the law is going to change. As a large number of petitioners were present in the courtroom, I decided to exercise my power under section 185 of the Indian Evidence, and I asked some questions after administering oath to 7 of such candidates, being petitioner numbers, etc.
Yes.
Millard, section 165, as your lordships know, Millard, this is exercised by the court or the judge in course of trial to elicit some points which may have been left out by the prosecutor or the cross-examiner, or to get some clarifications if required. Or if the court finds that the cross-examiner is not putting the right questions. Now the court, Millard, takes upon itself the burden, in my very respectful submission, a misconceived burden. Kindly pardon me, Millard, for adding this expression of exercise of powers under section 165.
Yes.
First, Millard, the judge holds the trial. Then the trial is over in the next sentence. Please have a look to that.
Yes.
The next page, Millard. From their evidence, I am satisfied that there was no aptitude test for the said petitioners. Trial over. Finding given.
Yes.
Learned advocate for the board has submitted that he does not have any idea whether such aptitude test was taken or not. In such circumstances, now, Millard, the court is eliciting, Millard, documents, evidence. In such circumstances, I direct the president of the board to file one affidavit by 7 days from the date disclosing whether there was any aptitude test in 2016 selection process and what is the method the board is following this year to take the aptitude test of the candidates. It goes, this year means, Millard, it goes beyond the writ petition. This was 2023. When, Millard, the 2022 recruitment process was ongoing.
No, after this 165 episode, your advocate was asked that you submit the documents. Reed court cannot call for documents, Mr. Doctor.
Yeah, definitely. The Reed court has the power of certiorari. Reed court can definitely call for documents, but not allegedly after exercising power under 165. Milord, your lordships have the power. In a case, Milord, your lordship finds that there is some disputed questions of fact which can be resolved by way of production of documents, because disputed questions of facts are not always barred for adjudication by the Reed court. No quarrel on that issue. But situation under which, Milord, the Reed court exercises its powers in adjudicating disputed questions of facts are where your lordships find that from the documents on record, a disputed question can be adjudicated. And for that purpose, Milord, one or two documents here and there missing, your lordships may call for that.
You did not challenge these orders at that stage.
No, these were not challenged.
Yes, next, what you want to show?
Yes. Then, Milord, the president of the board is directed to, Milord, file an affidavit that was filed. I'll take your lordship, Milord, in the pleading sequence. Now, kindly take note the next order dated 24th of January 2023.
Yes.
I directed the petitioners that at least 2 candidates from each district are to be present before this court, as the court wants to know from them about the interview and the aptitude test taken by the board in 2016 selection process. Milord, parties call witnesses.
Yes.
Both under the Civil Procedure Code as well as, Milord, the Evidence Act, it is the party to a proceeding who calls their witnesses. Court is not powerless. Court can also call, Milord, a stranger to come and depose. But ordinarily, it is the parties who are to produce their witness in a trial. Of course, Milord, I need not, Milord, dilate before your lordship that these trials are not held in the writ jurisdiction. But kindly consider, Milord, how the case proceeded. So I directed the petitioners. Or, Milord, my submission is the court calls witnesses over here.
Mr. Dotto, this has merged with the final order.
This is, Milord, this is why this is essential. Why I am troubling your lordship with all this is that finally, Milord, my point would be predisposition of mind of the court. Now, in order to prove this predisposition, Milord, how the case was conducted is required to be demonstrated before the court.
Yes. Which page next?
Milord, 24th of January order, kindly take the last 2 lines. I am told by the learned advocate for the petitioners that the candidates are present. Now I start exercising my power. Under section 165 of the Indian Evidence, as I want to take evidence of the candidates from each district. A procedure completely unknown. For a moment, Milord, my submission is not that the writ court cannot take evidence. There are exceptional situations where the writ court can take evidence. This is not one of those where the court elicits documents, the court elicits, Milord, evidence for the petitioners. The court is collecting materials for the petitioners. I'll gradually, Milord, I'll demonstrate before this court. That is, Milord, a procedure which is not permitted by law. But Milord, writ proceedings are, Milord, Order 19 proceedings. They are adjudicated based on the affidavits that are filed before the court and whatever are annexed to those affidavits and the writ petition.
Allegation was a scam to whatever may be the procedure. The court, Mr. Dotto, cannot go to the nitty-gritties.
Now, what
Now
was the
you have-
final GSS? But Milord,
We understand your argument. Now you tell us that whether it is absolutely you are showing, you said so, that predisposition of the court's mind.
yes,
That these were the rudiments on the basis of which the court has come.
yes.
Yes. Yes, then
Then Milord, now I start, etc. Some names from each district have been intimated to me by the learned advocate for the petitioners who were candidates in the 2016 recruitment process and appeared before the interview board, but all of them were unsuccessful. Though the name of one Shankar Thapa representing Uttar Dinajpur was mentioned in the list handed over to me by the petitioners, Mr. Thapa is not present, and I have taken evidence of 19 candidates exercising my power under section 165. I have received the affidavit as was directed by this court on 17/1/23, affirmed by the president of the board, which is kept on record. The instruction of the board under memo dated 11/1/23 was shown to the court and handed over to the learned advocate for the petitioners by the board. The petitioners have come up with one exception considering the said memo, that is the instruction affirmed on so and so, which is also kept on record. The respondent board wants to deal with the said exception. The board wants to file one affidavit in opposition to the writ application for which no prayer was made and therefore no direction was given. Now at this stage, when the evidence of a large number of petitioners have been taken, which are throwing light upon one of the allegations of the petitioner, I will not allow filing any affidavit in opposition in this matter by the board. I direct, but another affidavit is being directed, the president of the board to file one affidavit further explaining what is an aptitude test. And this explanation is to be given after consulting the experts in the teachers training field. And the names of the experts are also to be given to the court in a sealed cover, and it will not be disclosed to the petitioners. The president of the board is also directed to produce one list in a sealed cover, which will not be given to the petitioners, which will contain a list of names of the interviewers and their designation in respect of the interviews of the candidates whose evidence has been taken by this court. This list shall remain a secret list, so and so. Direction given to the petitioner, etc. Then, Milord, your lordship may take, Milord, the next one where, Milord, seal cover proceed. I mean, everything was given in seal cover. That is where that is recorded here on the 6th order of 6th of February 23. Page cover at page 427.
yes.
Please take note of the second paragraph. First paragraph is the affidavit was filed by president as directed. Second paragraph is the letters issued by the board to different experts as to aptitude test were in a seal cover which has been opened in court, and those letters were kept inside again after perusal of the same by this court, and that envelope should be sealed again. Another sealed envelope containing list of persons who took interview of different districts, namely districts of so and so, have been produced, and those lists are contained in small sealed envelope which are kept inside the big sealed envelope. Out of those interviewers, the envelopes in respect of the district of Hooghly, Howrah, etc., has been opened and kept in a separate pile. The other small envelopes in respect of other districts have not been opened, and they are kept in a big envelope, and that big envelope is to be sealed again. Out of the interviewers of the following districts, namely so and so, I need to know some facts about the interview and aptitude test, and whom I call for appearing before this court on 21st of February. So now,
yes.
Now, Milord, interviewers are being called, and I call for and whom I call for appearing before this court on 21st February at 2 p.m. and the expenses of their journey, etc., I don't want to saddle. The amount to be paid is so and so. I do not call all the persons named. For the district of Hooghly, I call persons named in serial number so and so. Then other districts so and so. On 21st February 23, this proceeding of asking some questions to the interviewers would be done in camera, and their reply to the questions would be recorded. List this matter on so and so, the board is directed to so and so. Now, please take, without skipping over one order, please take the order of at page 432. This is also of 6th of February. Where on the same day, two orders were passed. One in the first session, the other in the second session. The second session order is at page 432.
432.
Yes, ma'am.
No, yes, yes.
But this is in the second half. Pursuant to the order passed.
Date returnable was 21st February. In the
earlier one, but this
was taken in the after.
Yes. Pursuant to the order passed on 6th of February, evidence of the following named teachers who took interview of some candidates in 2016 recruitment process for so-and-so, conducted by so-and-so of the district of so-and-so were taken up. The real question was...
No, were they those interviewers in paragraph 7 of the earlier order?
Yes, they are the interviewers who were called
by the 6th of February order.
Yes.
So they were present in court.
Appears to be so. Thank you.
So thereafter they were interviewed. Very good. Now.
21st হবে?
21st February.
Data wrong.
21st August. Yes, that is what is written.
ওটা কত হবে? এটা 21 হবে?
This is 21st February. Oh, not on the same day.
Very well, I stand corrected. But I am told in the website, ঠিক আছে বলছে যখন
Very good. This is 21st February.
Yes, when my learned friend is saying so, I will not contradict.
So on that day, the interviewers came. Yes.
So pursuant to the order passed on so-and-so, evidence of the following named teachers who took interview of some candidates in 2016 recruitment, where 2023 these persons are being called. Evidence of the following who took interview on 2016 recruitment process for the so-and-so of so-and-so districts were taken up. The real question was whether the aptitude test of the candidates were taken or not. Well, this is not a point raised in the writ petition. From the table below, the reply to the questions would be found. Where Robindranath Bhattacharya says no aptitude test, Rafi Kalam says test taken, Prabhat Roy says no test, Ratan Bala says taken, Arun Kanti Niyogi says not taken. Well, some say taken, some say not taken. I'll place everything was on record that aptitude test was taken at the appropriate time. But this is what has transpired, from the examination by the judge. Then after the table, kindly look into this sentence. No questions were asked by the appearing parties to the above interviewers. Matter ends over there.
Because the answer was partly in their favor. Because some said no aptitude test.
Maybe or may not be. But what is the legal position your lordship would kindly consider?
Okay.
The evidence recorded are kept on record. It is to be noted that there was no formal engagement letters for acting as interviewer. All of the interviewers were called over phone to take interview. There was no guideline for awarding marks for aptitude test, where the learned judge forgets the rules. A large number of interviewers were not intimated by the board that there is one aptitude test, a different test altogether also beside interview. One interviewer so-and-so said that he took aptitude test, but when asked what was an aptitude test, his reply was aptitude test means confidence and body language of a candidate. Therefore, 36,000 appointments should go. Then please take me to the next one, which is 5th of April 2023 at page 436. Where the interviewers over. Now kindly take me to 5th of April.
Yes.
I direct the superintendent of the Presidency Correctional Home to produce Mr. So-and-so physically before this court. The superintendent is directed to make arrangement for necessary police force, etc. Well, none of the parties had prayed that this gentleman should be brought before the court.
Yes.
So this was adjourned till 3 p.m. Now kindly take me the at 4:20 on the same day, this order was recorded. This is at page 437.
Yes, page 437.
5th of April 2020.
Have you been interrupted by anybody?
Mr. Bhattacharya is sleeping. And I and Mr. Sannal could not find any reason.
You should interrogate him.
Yes. Why should he be drowsy?
Yes, 437.
Well, the second paragraph, my lord. The hearing is not complete. Respondent board will make its submission in respect of the argument made today by the petitioners. Thereafter, the petitioners will be given opportunity to reply to the submissions to be made by the board. Pursuant to my direction, so-and-so was produced before this court by the so-and-so. Some relevant questions were put to him which were required to be known by this court.
Yes.
Some relevant questions were put to him which were required to be known by this court for full and complete adjudication of the matter. Mr. Bhattacharya has replied to that questions which are recorded as below. I am asking some questions to the erstwhile president of the West Bengal Board of so-and-so, exercising my powers under section 165. Mr. Bhattacharya, any selection committee was constituted for the 2016 recruitment process? Yes. The selection committee was constituted by the board. Who published the result and who prepared the result of 2016 recruitment process? The deponent first said that he does not understand the question. Then he said that it is compartmentalized and made some statements as to the compartmentalization. Whether any other outside agency was engaged to prepare the result of 2016 recruitment process, the board has acted in accordance with rules so-and-so of the recruitment rules. The question is, was any specialized agency engaged? Yes. What was the name of the agency? I have to go through the records. I cannot remember. Have you ever heard the name of P. Basu Ray and Company?
Yes.
Your Lordship will not find this name in any pleading.
Yes.
Your Lordships would not find this name in any pleading. I won't say anything more. Mr. Tiwari is here, Lord, he'll contradict me.
Yes.
Answer is maybe, I'm not sure. I have to go through the records. Did you know whether any aptitude tests for the candidates were taken? Yes, of course. Aptitude test was taken. There is no report during my tenure as the president of the board that aptitude test was not taken. Are you sure that the reservation norms were followed in 2016 recruitment process? Another additional factor comes. Reservation. Reservation policy was, as was incorporated in the rule itself, was followed. There was no allegation or information during my tenure that reservation policy was not followed. Mr. Bhattacharya, is there anything against you personally in respect of the matters pending before this court against the board, which are now in the hands of CBI or ED? No personal allegations till date has been made against me. The witness volunteers, without any pretext or context, the Honorable Court has asked me some question and I have given answers to that to the best of my knowledge. Mr. Bhattacharya was handed over to a correction law, etc. Fix on so and so.
Yes.
Order date টা বল Bhattacharya এমন কিছু নেই Well, on 12th, my lord, we pray for directions for filing affidavit.
Yes.
Then 19th of April also, my lord, affidavits. Then, my lord, the hearing starts. Hearing concluded. Now, my lord, take the judgment.
12th of April 23.
12th of May 23.
12, page 442.
It's no. I'm sorry, my lord. Yes, but I have it at 611. Your lordship may look from that page also.
611.
Yes,
So
it would be made in the other volume.
But what is this page 438? Or
Well, it's the same judgment. Judgment under the appeal. 12th of May 2023. It's at two places made. I have read it here from page 611. Yeah.
No, final order is 12th of May. Yes.
Now, this is the final judgment which is under appeal.
Yes.
This writ application has been filed by 140 petitioners who were qualified in TET 2014 and participated in the 2016 recruitment process but did not get appointment. The recruitment process was held by the West Bengal Board of Primary Education, which was to be held in accordance with the recruitment rules, which came into effect. Rule 6.3 of the rules in Rule 6, Sub-Rule 3 of the said rules, the following provision has been made. In the matter of appointment, priority shall be given to those eligible candidates who possess the minimum qualification as specified by the National Council of Teachers Education and MHRD, and thereafter the eligible candidates with the relaxed qualification specified by MHRD may be considered, and if candidates with relaxed qualifications are considered as teachers, such teachers under the relaxed qualification norms shall be appointed with an undertaking to acquire the minimum qualification specified in the NCTE within a period of 2 years from the date of appointment. Under the said rule, Sub-Rule 3, 8 notes are there which would be taken into consideration if required. When the petitioners filed the petition, they wanted the authorities to file a report disclosing name, numbers, rank, category, etc. of the non-trained candidates who have been recruited by the board from 2014, including the date of recruitment, and to treat the petitioners equally with the non-trained candidates, etc. During the course of hearing, the petitioners disclosed various particulars collected from the publication made by the board in its website, showing that there were serious illegalities in preparation of the panel of 2016 recruitment process when viewed in respect of untrained candidates at the time of recruitment, and while disclosing such particulars, they made it clear that all their allegations of illegalities in recruitment were in respect of untrained candidates at the time of recruitment who were given appointment against 2016 recruitment process. And at the same time, it was made clear that they do not have any grievance with respect to the trained candidates who were trained at the time of recruitment and were given appointment in the 2016 recruitment process. Therefore, the candidates who were trained at the time of recruitment are outside the scope of this matter. The petitioner prayed for filing supplementary affidavit, which was granted, and from the supplementary affidavit to the writ application, it became evident that all the petitioners had qualified TET 14 and participated in the 2016 recruitment process, and they were called for interview, but they did not get the job. The aptitude test calling which was recorded in the first order is missing. Now the honorable judge records that only interview. This court directed. Now the court is inviting or calling for evidences. This court directed the board to file one report as to the petitioner's breakup of the total score sheet of 2014, TET 2014, along with the breakup score of the last empanel candidate in their respective medium category and district who participated in the recruitment process of 2016. From the breakup, the petitioners found that the alleged that the particulars given therein are absolutely false, as because the lowest number of impanel candidates was shown in the report as 14.191, whereas throughout West Bengal, 824 candidates who scored below 13 were appointed, and the petitioners prepared a tabular sheet to that effect and enclosed it as Annexure B to their exception to the report filed by the board dated 11/1/23. Such exception was filed in the form of an affidavit affirmed on 24 January 23. It was also stated in the exception that list of the last impanel candidate of different categories, namely General SC, ST, OBC A, OBC B, was not given. I have found that there was no reply of the board in respect of the allegations as aforesaid in the affidavit in opposition filed dealing all the pleadings of the petitioners. From the pleadings of the petitioners, it is found that they wanted the marks of the last impanel candidate of different categories like SC, ST, OBC, etc., but no such particular were supplied and produced by the board despite direction given by this court. In the affidavit in opposition of the board maintained silence in this regard. This is nothing but suppression of facts from the petitioners as well as from the court. In respect of holding of aptitude tests, the chairman of the board in his report said that the aptitude tests were taken, but from the evidence adduced by the interviewers and the candidates, it has been proved before this court that no aptitude test was taken. We are pausing here for a moment, Pilot. All relevant records were before this court, which is part of the paper book, to show that in every district, Pilot, aptitude test was taken. But with respect, the honorable judge do not refer to any of them. The honorable judge confines this adjudication to whatever was elicited under section 165. Pleadings and evidence on the record, Miller, in my very respectful submission, has been ignored. In this regard, the order passed by this court in this matter on 6/2/2023, not challenged till now, is required to be quoted. Miller, that order is quoted, but I placed that order, Miller, with the...
No, Mr. Dotto, where they called for the aptitude test?
Yes, yes. We have all records annexed. I'll not go elsewhere.
So
This paper book itself.
The evidence which was extracted as you were submitting, that is relating to the issue whether aptitude test was held or not.
The issue which the honorable judge considers at the time of final adjudication is only confined to whether or not aptitude test was taken.
Yes.
Although, Miller, no pleading was there. That's why, Miller, I have taken your lordship through the writ petition. Then, Miller, if your lordships may kindly skip over the table at page 617, after the table, no question was asked by the appealing parties to the above interviewers. The evidence kept on record. It is to be remembered. This is the quotation of that order. I skip over those. Now, please take paragraph 10. Then page 618, para 10. Therefore, the marks given to the candidates against aptitude test is wholly illegal and false exercise to hoodwink all concerned, including the court. Paragraph 10.
Yes.
But so long, Miller, the finding was that no aptitude test was taken. The interviewers have made contradictory statements in course of their deposition. Now kindly see paragraph 10. Therefore, the marks given to the candidates against aptitude test is wholly illegal.
Maybe the judge thought that the aptitude test which had been held is not in terms and in consonance with the rules.
Well, let us simulate whether that has been held or not.
This issue as whether aptitude held or not, this I think will go because subject to what you say. Because maybe Lordship was proceeding on the basis that test which was held was a sham test.
Right.
That is, I think, the
Yeah.
ultimate.
There cannot be two
versions.
Two versions. Either the aptitude test was taken. If taken, it is faulty or correct. That can be one situation. The other situation was no aptitude test taken.
Okay.
So long, Millard, we had a understanding from the judgment that
there was no
aptitude test. Therefore, the marks given to the candidates against the aptitude test is wholly illegal and false exercise to hoodwink all concerned, including the court. The board has not given any reply in respect of awarding 9.5 out of 10 marks to a large number of candidates, which is absurd and an impossibility, especially to those whose academic score and TET score were very low. The table given below substantiate the allegation apart from 121 pages booklet, spiral binding, which is on record. Spiral binding cannot be a pleading or an evidence.
So who made the spiral binding?
The petitioners. Read petition.
Record with us.
Yes, that Millard we have put in the paper book. It's in the paper book.
Yes.
In support of their allegations as to corruption in awarding marks in the interview, the petitioners have filed a booklet of 121 pages on the basis of which it has been alleged that the candidate whose marks were very poor in secondary, in higher secondary and in TET has been given 9.5 out and 10 marks, that is full marks out of full marks 10, that is the perfect 10 in the interview and aptitude test. No aptitude test was taken at all, and the allegation that there was no aptitude test which has been proved before me. Who has proved this? The proof has to be preceded by an allegation, an assertion, a pleading.
Yes.
But how it has been proved, I'll come to that later on. But Millard, before coming to the conclusion that it has been proved,
yes,
one must come up with an allegation. Proved before me from evidences of the candidates and from the interviewers which are kept on record. Here to elicit the truth, I had to exercise my power under section 165. For example, some particulars have been given in the said 121 pages booklet, which has been prepared from the particulars published in the web portal of the board. By the board, some candidates' marks were reproduced herein below, which shows that the marks awarded to such candidates whose results are very poor in secondary and in higher secondary examination and also in TET are wholly absurd assessment in interview, and unless some extraneous factors which includes corruption, as has been alleged by the petitioners and now has come to light from the investigation by CBI and ED, such absurd marking could not have been made by the interview boards in different districts. While looking into the following particulars, it has been noted by me that in the academic assessment and TET, 1. The maximum marks that could be given against secondary examination score of a candidate was 5. The maximum marks that could be given to a candidate against high secondary examination score of a candidate was 10. The maximum marks that could be given to a candidate against TET was 5. Therefore, the maximum marks that a candidate can get against the above three heads is 5 plus 10 plus 5 is equal to 20. Now I give example of a candidate before giving a table prepared from the document or record, that is the 121 page booklet. This candidate has got 2.866 in TET out of 5, 1.462 in secondary out of 5, and 3.050 in higher secondary out of 10, totaling to 7.378 but was awarded 9.5 marks in interview and aptitude test. Aptitude test was not taken out of 10, whose total score came to 16 point so and so, and thus he became eligible for appointment as a primary school teacher. Huge number of such absurd awarding of marks has come to light through the said booklet prepared from the particulars published by the board. Miller examples given. For example, Putul Bormon Singho, total marks in the academic qualification is 7 point something, and the interview marks is 5.0. Similarly, Monimala, etc., etc. This is the Honorable Judge records. Then kindly, after the table, para 15. The board has not given any reply in respect of the allegations of the petitioners in the pleadings as to non-empanelment of the reserved category in the panel for general category candidates of those reserved categories who got better marks than the general category candidates in the open competition. Thus, the board has violated the law declared by the Supreme Court and has committed extreme illegality. Though the relevant Rule 7 of the Recruitment Rules of 2016 mandates constitution of the selection committee, no selection committee was constituted for the purpose of selection of eligible candidates and preparation of panel of such candidates for appointment of teachers. It was done by one outside agency, a third party, which was not at all a part of the board, and this third party was named as confidential section of the board. This is clear violation of the recruitment rules. The board has maintained complete silence. From the gross illegality in the selection procedure in recruitment exercise of 2016 conducted by the board, it is clear that the board and its officials, including the former president who is now in custody so and so, conducted the whole affair like affair of a local club, and now it is gradually coming to light by investigation of Enforcement Directorate that jobs of primary school teachers were actually sold to some candidates who made money to who had the money to purchase the employment. A corruption of this magnitude was never known in the state of West Bengal. A former education minister, the former president of the board, and a number of middlemen through whom the jobs were sold like a commodity are now behind the bars, and the CBI-ED investigation is being continued now in full swing. Well, with respect, paragraph 17 has got nothing to do with the merits of the matter.
It's a scam, Mr. Dotto.
That scam, what they say, scam, please see whether at all there was anything in the petition.
No, right. You have showed us that there was
nothing
no
was there. Simply using this catch expression, scam, corruption, scam, corruption, doesn't mean that a case is proved. A case has to be proved even if it is scam.
So there will be no perception of the judge.
In that case, the judge should first release the matter.
First?
Release the matter with respect.
Perception in the sense from the record.
No, these are not on record. These are the personal views of the judge. But how could the Honorable Court get the name of that third agency?
If it is ultimately shown by them that they are...
Whether it is shown by them, right?
These are all factors inextricably bound. You cannot segregate without...
No, these were not placed before the court. I'll come to all the pleadings one by one. It has to be there in the pleadings.
The pleadings you have shown.
Nothing is in the pleading. I'll come to the other pleadings. I've just taken your lordship through the writ petition. Other things where and the sequence of pleading is also very important. When did the court invite which pleading? That is also very important. Where I have a short list of dates for that also.
So that we will hear. We are just interacting with you.
Right.
We are asking you.
Yes.
When there is such a heart-throbbing issue of scam, which you say that it has to be different definitions can be given. But it is a fact that there had been a scam in respect of several education.
But that will not vitiate the other selection process. One selection process said to be bad doesn't mean the other.
Can be argued against you that in order to divert from that issue, you are taking up the very basics as to whether there were any pleadings. Maybe this may be an argument on their side.
Yes, definitely. But I will deal with those also.
Yes.
But otherwise, the whole the writ jurisprudence has to be rewritten.
Yes.
where your lordships have in a number of judgments held that whatever is there in the pleading as well as in the evidence, the court will only look into that.
Even except in extraordinary cases.
Yes. That extraordinary case has to be made out by the parties, not by the court. Court is not going to make out a case for one of the parties.
Yes. Yes, page.
Yes, ma'am. But I was placing paragraph 17.
Yes, 17. You have finished 17.
Yes. Now kindly take paragraph 18.
Yes.
Now kindly see about how we are being dealt.
16 17 শুরু করুন।
Acha, 17 when I have not started. From the gross illegality in the selection procedure in the recruitment exercise of 2016 conducted by the board, it is clear that the board and its official so and so night পড়া হয়ে গেছে. Now please take paragraph 18. This is very important for me. Kindly see about how my arguments are being dealt with. It is a matter to be noted that the board in its affidavit in opposition while dealing with the pleadings of the petitioners, instead of addressing the allegation of corruption and illegalities in the recruitment process, raised some niceties of law and some principles of law, but however nice or however laudable, those principles may be, this court as a court of justice will fail to deliver justice, knowing fully well that sense of justice is much above the sense of law. If the writ application is thrown out on such niceties of law, as this will mean that in the name of preserving the law, the corruption would be protected, with which a constitutional court can never do, keeping in mind the soul of our constitution and the constitutional conscience. I say that in this recruitment scam, stinking rats are being smelled. So whatever rubbish I have said, that has to be dealt with by the court. Kindly see the next sentence. Even more alarming, the board placed some judgment before me in support of the niceties of the legal principles, which I do not find have any applicability in the face of the magnitude of the stinking corruption in the recruitment exercise of 2016 conducted by the board. These judgments are not required to be mentioned at all. But this is how, my lord, the advocate is being dealt. Say that these judgments are not applicable because of so and so reason.
At all in the facts of this.
No, he has not. I have referred to at least 20 judgments, not even recorded. That is why, my lord, with respect, my lord, the Honorable Court, my lord, bypasses the application of the principles by saying that these are niceties of law. As if, my lord, in writ court, niceties of law is not to be argued. It is a Bhakcha's court. Kindly see. Now, kindly see the expressions thereafter. Those judgments are not required to be mentioned at all in the factual situation of the case, as those are the bright stars of the space, much above the ground realities, in which the unemployed youths live with tears in their eyes, because this recruitment scam is a crime against the society and also a fraud, where the board and its former chairman was well aware of the rules of the recruitment but cared a fig and started a play to hoodwink all concerned. I will only say that fraud unravels everything. Who has unraveled the fraud? Kindly, Lord, recollect.
Yes. Yes, Vishnu. So there are total 44 appeals in this. We were told. Now those are arising out of the same judgment. Now how many petitioners were there in all these matters? Total number of petitioners, how many?
Milord, may I say this, Milord?
How many challenged the selection process?
140.
Only 140.
Only 140.
More than 140?
No.
140 read petitions. Now, any other person came into the zone?
No, not in the appeal, before the writ court.
No, before the writ court we are asking. 140. All the 44 appeals, let us clear out the facts. All the 44 appeals are arising out of the same judgment. And all the appeals are dealing with the case of 140 writ petitioners. There were no other persons. Whatever application for addition has been filed is by the teachers who are already in service. Right?
Not only that, my lord, who are in the same footing of the petitioner, that application is also filed because their petition is also pending, and the board submission is that, my lord, due to this pendency of this matter, they are unable to address the court. So that's why the additional party and one of the additional party.
One.
My lord, can two already.
Yes.
In the first order, it is mentioned, my lord, can two is already allowed.
Who are the unsuccessful persons? So do you have that chart? How many persons in total are there? Anyway, please ascertain that. Yes. Yes, Mr. Dotto. No breather. Continue.
And there are several repetition pending.
Yes, we are on paragraph 20.
Yes. But I'll just finish this judgment, Miller.
Yes.
Para 20.
Yes.
Yes. Then where paragraph 20, the affidavit in opposition of the board was filed when all pleadings of the petitioners, including the particulars placed in the court, were served and kept on record, and the board did not deal with those allegations and those material facts and necessary particulars. In such circumstances, I allow the writ petition. The appointment of all 36,000 who were unchained at the time of recruitment in 2016 recruitment process conducted by the board in the post of recruitment primary teachers were cancelled for various reasons as elaborated above. The board shall immediately arrange for a recruitment exercise. Rest is, Miller, how to implement the order.
So this fresh recruitment exercise which the single judge directed would be restricted to the self-same persons.
Yes.
Yes.
So my first is, my lord.
Then?
But the other is, my lord, how, my lord, the judgment is to be worked out. Yes.
Such they will be acting as para
Yes,
teachers.
that may not be, my lord, essential for the present. Therefore, my lord, this is how, my lord, the litigation proceeded. One facet I have demonstrated before the court. The other is, my lord, as to when, my lord, the pleadings were called and what had happened in between. I'll place those also. Then, my lord, but maybe come back after the vacation. Maybe.
Why vacation, sir? You can finish your argument at least, because your argument, your judgments we will take into account.
Wait.
How long will you take, Mr. Dotto?
Well, at least one half, another one half.
1 hour.
One half, my half-hour day. Well, I have to show a lot of judgment. First is, my judgments which I placed. Whatever judgments I have placed, has not been notable.
Oh. on factual aspect, do you want to take us to any other document?
Yes, yes, there are some other documents which I need to take your lordship. But these findings were not based on anything.
Look at the
আজকে কত? আজকে কত রে? আজকে হচ্ছে 7। I minded to hear it this side of the vacation, Miller, in that case. Okay, bhai. Okay. জজ সাহেবের সাথে কথা বলছি, তোরা তো কথা বলাচ্ছি। আমি যদি বলি ছুটি করে করবো, জজ সাহেব না বলি?
Yes.
Miller, in that case, Miller, kindly keep it, Miller, in
It
the...
is not we are minded, it is our work. We have to finish it.
Yes, yes, yes.
It is our work. We would only request the councils to
Well, kindly keep it, Miller.
the time because it is awaiting decision for a substantial.
Right, right.
That is a request to the councils. Now it is up to you people to come and tell us.
Well, kindly keep it, Miller, in the week of 19th, starting from 19th.
Then on that day you are finishing your arguments, and it would
But
have
I
been
hope
very
so, Miller. But I hope.
helpful to us had we got the list of judgments which you are placing.
But that period I can supply to the court. Not today, but in between I can supply. That I can give.
And if on 20th 2 p.m. you cannot finish, if possible, we will keep it as a continuing matter so that you can finish your argument. Prior to the vacation, at least you can finish your argument. So that now it is their turn.
We have made submissions, madam.
Yeah,
We have to make submissions. We are the successful candidates.
You are added applicant, sir. Which appeal you have? Achha, please let us know.
May I explain, Miller? May I explain, Miller? I Partho. এক second. There are 44 appeals. One appeal is by the board. The other 43 appeals are by the successful candidates who have lost their job.
Right.
Or in other words, the 36,000 who have lost the job, many of them have preferred the rest 43 appeals. There are, Milord, certain...
Was granted to them.
Yes. And the applications which your lordships are facing, the addition...
The successful candidates.
No, they are the unsuccessful candidates.
Oh.
Standing on the same footing with the writ petitioners.
Or the writ petitioners.
Fence sitters will deal
I am
with
the candidate.
There are also successful candidates who have not been implemented. They have also filed an application for leave to appeal.
That the other appearance to decide among themselves who to the lead counsel evidence.
That way, I think, Milord, this matter cannot be decided.
At least there should be a subject to what you say. The arguments can be urged before us by any particular advocate. If any further addition required, let that advocate continue. I don't know. Pardon?
We will not repeat, but we may be given an opportunity to address it.
So you are the appellants, we will hear it. There is no problem with that.
The last question, my lord, also the same. Don't repeat. You want to say something new? You're always welcome.
No, no, not new. You will certainly place your case. We are just requesting you, at least if one council can urge so that time can be shortened. No,
No repetition.
No, no, you decide that who will be the council.
Start after the vote. Even at applicants, candidates.
So you sit together, sir. You don't expect the court to keep in abeyance for the entirety future. Don't insist unjustly. We have stated very simple sentence we have asked. We have said if there are 10 councils, you decide that who is going to say something. Maximum 2 persons we will give. This way it cannot indefinitely continue. We will not allow that. This is so you decide. We are not either Mr. Mitra or whoever is there. No, Mr. Devarman, this way we cannot, because then what happened? Heard Mr. Dotto adjourned till such and such. This we will do it for innumerable times to come. This court will not do. You wanting after vacation, we wanted that the original appellant will complete their arguments. That is Mr. Dotto and the other applicants who are similarly situated with them.
What happened, my lord?
Let us finish. So we will hear you, sir. We are wanting to curtail the time. So we would again request you that let one council address us. Let one council or 2 council maximum. No, 3 or 4. PP cannot. So you tell us when will you argue? You tell us the date that we will argue on that. 20th, Mr. Dotto is finishing.
Finish করবে কি?
Very good. Then you are continuing. So that we can finish off the persons.
Yes, before the vacation. Before the vacation, if your lordship, if your lordship permits. Yes, that will be the best. We can conclude it.
No, what we are just interacting with you. We cannot do on our own unless you assist. So we would be requesting the councils. We are fixing on 20th. Now, if suppose the person who will be arguing, he can continue till the next date. We can close the argument so far as the appellants are going. Please have something for us. There are 44 paper books we are told. So this is understood. So this is understood. We are keeping it on 20th. If Mr. Dotto will finish, and prior to the vacation, we will give you some occasion. You finish your arguments. Yes. You will get a chance to reply also. Let them start again. Mr. Dotto and senior appearing for the appellants in the appeal.
My lord, I will endeavor to conclude on the active
Please.
Yes, I'll definitely, but
What submission is there? Will there be? Sorry.
Okay, sir. You are also for board.
Addition
You are not for
or addition of party, handicap candidate, one handicap candidate.
Your addition of party applications are on record. Let us start. Let us start.
We
will take up all applications on a single date. We will hear you and we will add you or we will subtract. Oh, subtraction to nahi
It is not implemented.
Would request that please make your submission physically. Online, it is very difficult for us.
Physically.